Eastern Coalfield Limited. My lord, he's a working underground mines. Like he made an accident. My lord, he failed to, my lord, going to go, my lord, in the underground. Authority cannot join me, my lord, till today, my lord. I am suffering, my lord.
All right, it will be called on.
But I already served notice to the other side. If not called on, then my lord, kindly give some precedent, my lord. I already served notice to the other side.
Not today, it will be called on Thursday.
Yes. Permit to be mentioning, my lord, one restoration application, my lord. May your lordship kindly permit me to mention one matter. This matter was initially filed under wrong group head. It was filed under group 9 instead of group 6, and it was, I mentioned it before Honorable Justice Moushumi Bhattacharya, and her lordship has released the matter from her list. Now
it will appear as motion. Please give the list.
uh,
Give the slip. It will appear as motion.
but now the matter is lying in the administrative department, so
it will take time for the department to send the file. Please give the slip.
Grateful, my lord.
Item number 1, I am for the petitioner, my lord. This is that matter, my lord. No, sorry. My lord, only correction, my lord, is that the first line says, my lord, WPA number 2515. It should be only 2512 instead of the last error.
2515. 2512. See, এটা ছাপানোর সময় ঠিক মতো ছাপায় না জানি দুখানা রেকর্ডিং অফিসার তারপরে যদি ঠিক মতো না ছাপায় তো ঠিক আসুন
I'm sorry, my lord, for troubling, my lord.
Mistake is on our part, Mr. Chatterjee. What to be done? Ashun. By a judgment and order dated May 3, 2023. This court directed WPA 2512 of 2023 to be detached from WPA 8506 of 2021. Full stop. Inadvertently, it has been recorded that WPA 2515 of 2023 is to be detached. Full stop. Let the inadvertent mistake be corrected. Full stop. Next. Let WPA 2512 of 2023 be detached from WPA 8506 of 2021. Full stop. Next. Let this order be incorporated in the judgment and order dated May 3, 2023. Full stop. Serve upon.
Grateful.
Yes.
Lordship, on behalf of the respondents, my lord. Lordship, a victory appear for the petition, your lordship. Lordship, affidavit of service.
Yes.
Lordship, in this matter, petitioner is an employee. Is an employee of the Western Coalfield Limited, which is subsidiaries of Coal India, your lordship. In the year 2008, your lordship, petitioner was appointed as a mining sardar, your lordship. Now, subsequently, what happened, your lordship? Then, petitioner has obtained one bachelor degree of engineering, your lordship, and after that, petitioner have obtained, your lordship, a second-class manager's certificate of competency. I have annexed that.
This is within the territorial jurisdiction of this court. How is it possible?
Exactly, your lordship, because the head office of Coal India is situated in Kolkata, your lordship.
Petition is outside jurisdiction, my lord. The workstation also
Not maintainable on the ground of territorial jurisdiction.
Lordship, kindly consider one thing, your lordship. Coal India published the notification, your lordship, for the purpose of the promotion, your lordship. I have participated for the process of the promotion, your lordship, and the office of Coal India is situated in Kolkata, your lordship.
No wrong has been committed by the Coal India by publication of that notice.
Lordship, what has happened here? the publication of this notice pertains to the entire process, which is impugned. And Lordship, so far the appellate side rule is concerned, Lordship, if the head offices of the major number of respondents are situated in Calcutta, Lordship, this petition may be maintainable. Lordship, at the instance of various petitioners from outside Kolkata, these are maintainable here. Some of them are still going on in Calcutta High Court. So, Lordship, this pertains to the notice of the impugned notification, which is published from Kolkata now by Coal India. Kindly come to this.
The petitioner is working with the Western Coalfields. It should be maintainable before the appropriate forum there.
Now, this notification is a Coal India notification, which is annexed in page 18. There is internal notification for promotion selection from the non-executive cadre to the executive cadre in mining discipline to the post of senior officer mining in F2 grade. This is published by Coal India, a Maharatna
You
company.
are asking in your prayer
Yes, madam.
for promotion in accordance with this notification.
Yes,
You are
because
not
that is
challenging the notification.
Lordship, this notification, I am a beneficiary of this notification because Western Coalfield is a subsidiary of Coal India.
Yes, you are not challenging the notification. You are asking benefits
Out of
pursuant
this
to the
notification.
notification. No part of cause of action
Now-
has arisen within the territorial jurisdiction
Now-
of this court.
Lordship, therefore, Lordship, this is meant, Lordship, if your Lordship wants, I will come up with one or two judgment. Lordship, kindly give me one day.
This is not maintainable. Anyway, I am posting it after the vacation.
Yes, my Lord, kindly
Ashwin.
keep it. I'm,
Prima facie, I am of the view
yes, my Lord, I will try to satisfy.
The
all, then your
petitioner-
Lordship.
is an employee of the Western Coalfields Limited within bracket WCL bracket close full stop. The petitioner prays for consideration of promotion in accordance with a notification published by the Coal India Limited within bracket CIL bracket closed on September 30, 2022 full stop. Next. The said notification is not under challenge full stop. Next. Mr. Chatterjee, learned counsel appearing on behalf of the petitioner submits that since the notification of the Coal India is published within jurisdiction and the head office of CIL is situated within jurisdiction, this court has the territorial jurisdiction to receive, try and entertain, the instant writ petition, full stop. Next, Shomrat appears on behalf of CIL and submits that this court has no jurisdiction to entertain the present writ petition, full stop. Next. Prima facie, this court is of the view that this court has no territorial jurisdiction to receive, try or entertain the instant writ petition, full stop. However, at the instance of Mr. Chatterjee, this writ petition is posted for further hearing under the heading motion bold day on June 20, 2023, bold day. Full stop, server copy.
Grateful, my Lord, I will try to satisfy.
I put a page in a minute.
For the state this one. Lead by Ms. Chaitali Bhattacharya.
But I have all the respondents, including my private respondent. He is happy to be service member. Private respondent. My Lord, you will also kindly see page 22, my Lord. These are for scheduled caste and scheduled tribe candidate. Scheduled caste and scheduled tribe candidate. But my Lord, appointment given the general caste, my Lord. This is my given. So I'm page 22, my lord. Is a guideline.
Giving preference to SC/ST candidates.
Yes,
during
my lord.
Selection of
I
ASHA.
am the scheduled caste candidate. Scheduled tribe. But my lord, they have given the appointment.
Page 28.
Yes.
Next week, my lord, next week, my lord.
Yes.
This is my agreement, my lord. I am the scheduled caste candidate. I am eligible to get that job, my lord. But they have deprived me. They have given the general caste, my lord. Namely, my lord.
Where is the vacancy?
Yes, my lord.
As per the vacancy list,
One vacancy, my lord. One post.
yes, as per the vacancy list, which category was it reserved for?
Yeah, for scheduled caste and scheduled tribe.
Show me from page 20.
এই যে reserved for আপনি বলছেন সেটা কোথায় বলছেন?
Yes, please speak on the microphone.
Lordship.
Yes.
My lord, as per my instruction, my lord, this post is not for reserve, my lord.
So you show me from page 20.
Page 15, my lord. Looking for engagement of ASA.
Page, please speak on the microphone. Please speak on the microphone.
My page 20, page 15, my lord. This is the notice for engagement of ASA. Page 15. CL number 5, my lord. Area village where the majority of the population belongs to scheduled caste, scheduled tribe candidate. Preference will be given to the candidate from that category. 5, my lord.
Keeping the selection criteria fixed. Keeping the
Selection
selection
criteria
criteria
filed by
fixed.
sub-division ASA selection
You filed
committee
a
and
report
sergeant of
explaining
the
what you
preference
think
will
are-
be given.
Lordship. But my lord, apart from that, my lord, this is his submission, my lord, that they are on that locality, SC/ST.
So you have to explain it on
Lordship,
report.
lordship.
The grievance of the petitioner is that
Reserve not.
even though preference is required to be given to the scheduled caste stroke scheduled tribe candidates in selection of accredited social health activists within bracket ASHA, bracket closed, Kormi, comma.
Preference দেওয়া
General
reserve
category candidate
আলাদা।
being the private respondent number 8 was chosen in place and stead, chosen comma, in place and stead of the petitioner, full stop.
আমি কনসিডার চাইনি পেয়ে যেতেন।
উনার নামটা কি হতে পারে? Next.
Yeah, but
Learned counsel appearing on behalf of the petitioner submits that pursuant to a notice for engagement of ASHA dated April 21, 2022. The petitioner applied for engagement
Number
in block hyphen Raghunathpur 2, under Raghunathpur subdivision,
Raghunathpur. Raghunathpur sub
district
Purulia.
Purulia.
hyphen Purulia. Full stop. Clause 5 of the said notice stipulated that the area within bracket village where the majority of the population belongs to SC/ST, preference would be given to the candidates from that category, comma, keeping selection criteria fixed by the subdivisional level, comma, Asha Selection Committee, full stop. Next. It is submitted on behalf of the state respondents that no infirmity has been committed in selection of the private respondent number 8, full stop. Next. Considering the submissions of the parties and the materials placed on record, this court is of the view, recorded per comma, this court is of the view that the justice will be subserved by that justice will be subserved by directing the state respondents file a report on affidavit clarifying clause number 5 of the eligibility criteria stipulated in the notice dated April 21, 2022. Full stop. Furthermore, it has to be clarified in the said report why the private respondent number 8 was chosen. Was given preference in the selection process compared to the petitioner. Full stop. Next, let such report and affidavit be filed by
2 weeks after vacation? 2 weeks.
June 23, 2023. Full stop. Exception, comma, if any, comma, by June 30, 2023. Full stop. Let the matter appear for further consideration under the same heading motion bolded on July 3, 2023. Full stop. আর প্রথমে affidavit of service filed in court today be detailed.
I'm getting it.
Get from it.
যদি কোনো একটা পোস্ট থাকে 10% রিজার্ভেশন কখনো পায় না।
হ্যাঁ, single put.
Grant for the state.
The petitioner people opposite party,
Yes, please speak on the microphone.
my lord, government employee, my lord, working under my lord different departments.
Government employee.
Yes, my lord. What happened, my lord, there is a agitation of in regards of the DA, my lord, lawsuit knows, and that is going on several days, my
They
lord.
are claiming the
Therefore,
government
they-
employee, then they should go before the
Yes.
state administrative tribunal.
No, they are actually, my lord, self-government employees. So they
You
can.
are saying they're government employees. I asked
No,
you.
no,
you say
self-government,
yes.
they are getting salary from this year. Panchat department, that is my lord. And my lord, losses can come to, that is my lord, there is a agitation, my lord, and thereafter my lord, they called a cease work on 10th, my lord, losses, my lord. They will have to remain absent from the duty. And lordship knows that the DA in question is, my lord, in every state they are getting, my lord, and more than state government of West Bengal, they are getting more. And as such, my lord, they give a notice for the strike. And losses kindly come to page 21. Page 21, my lord, that the notice for strike. notice for example, the strike notice has to given for before 14 days, my lord. Before the strike called on 10th March, my lord. Proceedings. And thereafter, my lord, a memorandum issued by the Additional Chief Secretary, Finance Department, my lord. That is on 9th March 2000. That is at page 22. Page 21. My lord, losses kindly come to third paragraph. Third paragraph, it is further notified that the absence of employees on the day will be treated as a dash non-break in service and no salary will be admissible unless such absence is converted by a ground following.
Covered.
So, covered by Vala. Losses can you see 3 punishments has been stated. Dash non, there is no provision of dash non in the service rules. Second, cutting of salary. And third is break in service. It is one then I have sent a demand justice before coming. Demand justice immediately that we have given notice. As per notice, we are given for strike. And losses can say there is another motion move in 2015 in similar circumstances when the state government said that we will not take any action.
Court has not decided the issue, my lord.
And the losses can come to.
Only give directions for affidavit.
Or your lordship can,
not
do
to give
that
a,
your lordship kindly
I am
direct
coming to the
as
law,
because
my
the
lord.
representation is pending before the additional chief secretary. He may dispose of the same.
That
my
is
lord,
no,
within
it
such-
cannot be, they will dispose of because they have issued the punishment notice. So they will not decide in our favor.
None,
So,
no,
losses,
no order has been passed.
let
No.
me submit, please.
Yes, what do you want?
Mala losses kindly come to. Get to them, filter them.
What do you want now? It
Well,
can only be
At least,
decided
my
on
lord,
filing of
losses kindly
affidavit.
come. Losses kindly come to, my lord, the West Bengal service route. I have given, my lord, at page, my lord.
Without filing of affidavits, how can it be decided today?
My lord, I am submitting one thing, my lord, that at least the service rules has given right to call strike. My losses kindly come to page 118. Because they are giving. Oh, my lord, now, sorry, page 292. Page 292. my
I cannot hear you. If you don't speak on the microphone, I
lord,
won't be able to
page
hear you.
292.
Yes,
My lord, losses can come para 4, rights.
yes.
Rights, my lord, it is rules. The following shall be the rights of the state government employees. Every government employees shall have the right to form an association, unions, federation, bodies and employees. Second, every government employees shall have full trade union right and in the right to strike. Right to strike. The right to strike shall be subject to the compliance of the provision of the appendix. And then, my lord, appendix at page, my lord. Page.
I cannot decide the issue today at the new motion stage. You have to understand this.
One thing more, my lord. They are giving punishment every day. They have annexed, my lord. And they are not only that, they are giving 3 punishment. Salary cut I can accept. Because salary I have not gone there, you are not given the special leave, you can deduct. But dash no, there's no provision for dash non in the
So how
service rule.
Can I decide without them filing? the
No, well,
affidavit?
in the meantime, not to give effect this of this, yeah. At least, man, this is because last we have seen that 3 punishment has been suggested.
Till now, they have not taken any decision, my lord. How is?
But they have taken decision. I'm
I-
showing, my
either-
lord, they have.
Either then your lordship can
Federal
direct
losses can.
the additional chief secretary to decide.
No,
the
no.
pertinent-
He has issued the notice. He cannot decide. It is this policy of the
Ashwin.
government. So it has to, my losses can come
The
to,
petitioner
my losses can to
has
page
straight for
30, page 30. Already imposed
washing
the,
of
punishment, my lord.
an order passed by the
Additional chief secretary.
additional chief secretary, Government of West Bengal dated March 9, 2023. Full stop.
And there may be a short abridgment if losses, please.
How many court fees have you paid?
Yes, sir, my lord. One.
How many court fees have you paid?
One, my lord.
Why have you
Yeah,
paid one court
3%.
fees?
No, I'll pay, my lord. I'll pay.
প্রথমে লিখুন, undertaking is given to pay the deficit court fees within the course of the day. Full stop. Next. কি হলো? Petitioners have paid. By the said memo, the additional chief secretary stroke the respondent number 2 notified the
At page 22, or 9th in March.
notified. Why are you disturbing the court?
My lord, sorry.
Do you have no faith in the court that the court will be able to dictate an order?
I'm helping your lordship.
Follow. Notified the state government officers that all the employees who joined the strike on March 10, 2023 and remain absent on the said date, their absence would be treated as dias-non within bracket, break in service, bracket closed, and no salary will be admissible to them unless certain grounds were shown. Unless certain grounds were shown, full stop. The grounds enumerated are reproduced hereinafter. হ্যাঁ, এখানে page 22 থেকে করে নেবেন, যেটুকু right দেওয়া আছে, page 22 of the petition. Next. ওনার নামটা দিয়ে দেবেন. Appearing on behalf of the petitioner submits that the employees of the state government had a right to form trade unions, including the right to strike, subject to the compliance of the provisions laid down in Appendix-Roman 1 of the West Bengal Services within bracket duties, rights and obligations of the government employees, bracket closed, rules, 1980, full stop. Next. Mr. Pal, learned counsel appearing on behalf of the state respondents submits that no steps have been taken pursuant to the memo dated March 9, 2023, and as such, the writ petition is premature, full stop. Next. Considering the submissions of the parties and the materials placed on record, this court is of the view that no case is made out for interim stay of the memo dated March 9, 2023, full stop. The said memorandum has been issued prior to the date of strike, full stop. Next, in the circumstances, let an affidavit in opposition be filed within 6 weeks from date, full stop. Reply, if any, within 2 weeks thereof, full stop. Next, parties will be at liberty to mention the matter within inverted commas for hearing, bolded, comma, upon expiry of the period stipulated for exchange of affidavits, full stop. Server copy.
Malad, if any steps taken in the meantime, Malad, that losses kindly.
Have to make an application.
Well, already Malad have annexed lots of, that is page 30 I have
In
stated.
respect of the other person, not.
Yes, Malad, in respect of this department.
My lord, I beg to appear on behalf of the respondents.
May it please, my lord, I appear for the petitioners, my lord. My lord, this is my writ petition, my lord, challenging the act of the respondent authorities in not granting me promotion. Lord, a very short facts, my lord. What has happened, my lord? If your lordship wants, I can delve on the facts, or rather I'll take your lordship through the impugned order and then my representation. So, my lord, in this matter, my lord, what has happened, my lord? I was working as an area sales manager looking after the sales and customer of Coal India Limited, my lord. My lord, in sometime in 2014, there was a shortage of some coal blocks, my lord, out of which, my lord, I was leveled as a person who was involved in that shortage. My lord, thereafter, my lord, on the basis of a letter in 2014, a charge was initiated in 2016. That, my lord, that was ultimately decided in 2018. And my lord, I take your lordship through the impugned order. It's at page 173. The operative part is at page 175. I will not trouble your lordship with the facts and findings because, my lord, we have ultimately suffered the penalty. Now, my lord, the last part says at page 175, the first paragraph. Now, therefore, the undersigned in terms of prayers conferred upon him as disciplinary authority under the Conduct, Discipline and Appeal Rules of 1978, hereby award a major penalty of reduction to a lower stage for a period of 1 year without cumulative effect upon Sri Madhukar Ranjan. Madhukar Ranjan is the petitioner herein. Now, my lord, kindly have a look at the rules, my lord. Lord, rule 27.1. That is the major penalty, my lord. 27.1.2. It's not paginated. Your lordship will have to find.
না না আমাকে যে ওই পোর্শনটা নেই
এই পোর্শনটা আচ্ছা আমি দিয়ে দিচ্ছি পড়ে Yes, my lord.
Yes.
My lord, 27.12 major penalties, that is reduction to a lower grade or post or stage in a time scale. Then, my lord, there's a note. The authority ordering the reduction shall state the period for which it is effective and whether on the expiry of that period it will operate to postpone future increments or to affect the employee's seniority, and if so, to what extent. Then, not compulsory retirement removal, that is not required, my lord. Only A is required. I was given the punishment under A. Now, my lord, what has happened, my lord? This order is dated 2018. And as I just said, my lord, the allegation was made in 2014, charges were leveled in 2016, and orders passed in 2018. My lord, from 2014 till now, my lord, on the basis of this order, my lord, my promotion has been, my lord, stalled. No explanation provided, nothing, my lord. To that, my lord, we have written letters earlier also, and my lord, thereafter letters we have written subsequent to this order also. But, my lord, no reply to this particular letter. My lord, and the other thing, my lord, I'd just like to point it out. Yes, my lord. My lord, as per the rule, my lord, the rule is very specifically clear, my lord, that after I suffer the penalty, which I have suffered, I have not challenged this particular order, I have suffered this. So, my lord, my contention is after this 1 year period without cumulative effect is over, I am entitled to promotion, my lord. I was entitled to promotion beforehand also, my lord, and I'm entitled to promotion after 1 year from the date of this order, to which, my lord, I am deprived. Now, my lord, the thing is, my lord, I have only 5 years of service left. I have written several letters. They have not even responded at once, my lord. And my lord, obviously, along with promotion, my lord, the difference of pay that I'm entitled to, and my lord, the benefits coupled with it. And the last letter, my lord, that's the letter before filing of this writ petition, my lord. It's at page 176, just thereafter, my lord. This letter was received by them, but it has not been replied to as on date. Only, my lord, I shall place the most important paragraph, which is, my lord, it is to at page 177. It is to further state that his juniors, that is the petitioner's juniors, have been promoted and are now senior to my client, which is not only humiliative but also disgrace of dignity, in spite that there was no fault on my client's part. I have suffered the order, I have accepted the order, but, my lord, I have not even received the promotion which I am entitled to, because the rule is very clear and the order is also very clear. It's without cumulative effect. So, my lord, 1 year from that date of the order, that ends in 2019 June, I am entitled to promotion, my lord, from that day, and, my lord, beforehand also, because there is no binding from the rules as on such that when an investigation will be carried on the basis of a charge, you are not entitled to a promotion. So, my lord, on and from 2014, when my promotion was stalled, I am entitled to, my lord, the promotion and the difference pay, along with after 2019, when I suffered this order, I accepted this order, and I, my lord, did not challenge this. But this is my limited prayer.
My lord, so far as the petitioner is concerned, he was, my lord, employee of this Central Coalfield Limited, Ranchi. He was not employee of Coal India. My lord, after he has, my lord, suffered the penalty, dates back to 2018. Admittedly, my lord, he has not preferred any appeal before the appellate authority within the time stipulated for.
He doesn't need to, he's accepted.
Now, my lord, in order to, my lord, claim promotion, petitioner has to come up with specific averments that he has joined the service in particular date. From this date, he became eligible to get promotion in this post, and his junior got superseded. His junior superseded him. My lord, there is no specific averments from wherein from it will appear that what is his case. He has, my lord, only, my lord, kindly come to page 26 of the writ application. Page 50, my lord.
1-5.
1-5. 1-5, my lord. 15, my lord. Prayer A. A writ in the nature of mandamus commanding the respondent authorities to give effect. I presume they must have claimed not to give effect to the order dated July 20.
He wants you to give effect. It is only for a period of 1 year. He
Without
wants you
cumulative.
restricted to that 1 year and then continue with his normal course of service. That is what he wants. It is not to give effect. He is suffering. He has suffered the penalty.
Yes,
He is saying that he has suffered the penalty already. Then why will he not be considered for promotion?
My lord, so far as my instruction is concerned, that he after the punishment period is over, he is, my lord, eligible to get promotion as per the, my lord, norms. My lord, but the difficulty is, my lord, he has not made out such case in the writ petition. He has not indicated, my lord.
Doesn't matter. You have to say, as per the law, if he is eligible for promotion after completion of his period of penalty, why have you not considered him for promotion? Why is the inaction on your part? You explain that.
Then, my lord, kindly, my lord, give me, my lord, some time, that let me, my lord, get back with, my lord, instruction. What is the present status of this employee?
First, you tell me that this disciplinary order, where is he working now? Do I have the territorial jurisdiction?
Yes, my lord. That is what I am saying. I think he is not, my lord.
Not you think.
My lord,
You have to give specific.
He was not. He is, my lord, not employee of, my lord, Coal India.
Where is your written instruction?
No. Lord, at page 175, my lord, it's there. I'm still in Coal India. Not Coal India, other Central Coal.
Central Coalfield Limited, my lord.
Central
Then
Coal.
you, then why have you filed
Yes,
it
my
before
lord.
this court?
Reside,
why-
my lord,
that
within
is
the
why, my lord, I
jurisdiction
pointed
of
it out
this
that he
honorable
was, my
court.
lord, employee of CCL Ranchi, CCL Jharkhand.
हाँ, sure. The petitioner is working with the Central Coalfields in the state of Jharkhand.
Lord, may I?
Full stop. In the petition, he has challenged inaction on the part of the respondent authorities in failing to consider him for promotion after completion of the period of penalty issued by the disciplinary authority. V-Day order dated July 21, 2018.
The disciplinary authority of the Central Coalfield Limited.
Full stop. Next. Considering the submissions of the parties, this court is of the view that this court does not have the territorial jurisdiction.
No, my lord. My lord, just to answer your lordship's query.
Receive, try and entertain the present writ petition. Full stop. In such view of the matter, WPA 956.
Lord, may kindly hear me out, my
23,
lord, on the territorial jurisdiction, my lord.
Hold it. Is dismissed.
My lord, may kindly hear it me out, my lord, just for a minute, my lord, then your lordship may pass.
They will be at liberty to take appropriate steps before the appropriate forum, if so advised. Full stop. Since no affidavits, server copy, certified copy. WPA ta bold or dismissed bold? Yes.
My lord, Central Coalfield Limited, my lord, is the subsidiary of Coal India Limited, my lord.
All
This
right.
point number 1 is, my lord, within the jurisdiction of this honorable court.
Thank you.
My lord,
My lord, I am appearing on behalf of the state, my lord.
Lordship, Mr. Surjabhusha Chattopadhyay is appearing for the petitioner. He has not been able to come today due to his illness. He's running a fever of 101.
20th June,
Your Lordship, considering the urgency, if your Lordship kindly keeps it on Thursday.
not possible anymore. 20th of June.
My lord, in this matter, I beg to appear for the petitioner led by Mrs. Aparna Banerjee, my lord.
Yes.
My lord, in this matter, my lord, petitioner challenged the transfer order, her transfer order. Prior to that, my lord, another transfer order of her husband was issued, my lord. That is also under challenge, my lord.
All right.
That is appearing as item number 82 of today's list, my lord. If my lord takes up both the matters together, my lord, then my lord, since both of them transfer to different places, my lord, in Assam, for that purpose, my lord, if my lord takes up the matter analogously, my lord, that will, my lord, serve the purpose.
82 টা আছে?
82, my lord.
You want to do it now?
My lord, subject to my lord convenience, my lord. If my lord or my lord can fix the matter tomorrow, subject to my lord and convenience, my lord. Tomorrow, if both the matters.
Transfer orders challenge on different grounds altogether. I don't know what resemblance does the first matter have
with the second one.
So since Mrs. Banerjee is briefed,
Yes.
that's why I was asking.
Personal difficulty is something else.
If my lord takes up tomorrow, my lord, that
Tomorrow will be difficult to accommodate.
day after tomorrow,
Thursday te রেখে দাও।
my lord,
Thursday te আমি new motion ই নেবো। Thursday.
new motion. Grateful. my lord.
Is it convenient for you, Mr. Mujumdar?
Extreme.
My lord, in 16, my lord,
Lordship,
Uh,
16, I am for the petitioner, Lordship.
my lord, the copy has been served at Delhi, my lord, and one at Jammu and Kashmir. We here do not have a copy. If your lordship kindly direct the petitioner to serve us a copy, or my lord fix it after vacation.
Mr. Toto, where should one serve?
My lord, Ministry of Law will do, and BSF campus is there in Calcutta.
What I'm saying is
That's
that
served,
Union
that's
of
served,
India,
repetition
where
service.
should one serve in Calcutta? Because in most of the cases, it's being served in Delhi. People are not appearing. Over here, as far as the state respondents are concerned, one can serve at the GP's office. As far as the Union of India,
My
where
lord, ASG's office is also there, my lord, in our court, my lord. Learned ASG's
and
office.
will the ASG accept service for Union of India?
My lord,
and
then
all that?
we like, my lord, come back taking instruction, my lord. Oh, my lord, Ministry of Law and Justice at Strand Road, my lord. As I,
Ministry of Law and Justice at
Strand Road,
because in many matters, I'm facing this difficulty.
my lord.
Because it is being served at Delhi and no one is coming, served at Jammu and Kashmir, no one is appearing.
My lord, if your lordship allows me, I will today, will converse with learned ASG, my lord, as my lord has directed, and then I'll come back.
Please get back to me.
Lordship, there is no specific instructions like that. And lastly, Lordship, I
There
have
is no
served them-
instruction. I am trying to solve it in a practical manner. It's not a question of instruction.
No,
I am
no,
trying
Lordship.
to help the litigants
Yes,
over
Lordship.
here.
And
Yes.
Lordship, I have served them, three
Yes,
respondents.
my lord,
All
but
right.
outside
Some
Calcutta.
They haven't received as yet.
If they
5th of
serve us a
June,
copy, or my
I'll
lord, after
serve it,
vacation,
5th of June.
my lord, my lord,
Come back on the 5th of June with
Lordship.
instructions.
Lordship,
Miller.
I'm good.
my lord.
In the
If
meantime,
your-
Lordship, I will serve him.
And you
If your lordship
get
kindly
back to
fix it on 6th, my lord, because 5th will be a reopening, we'll take instruction from the department on 6th.
If you take, there is enough time now, the 3 days.
My lord, we will not be there.
You also get back to my officer with regard to service in cases where service is.
My lord, I'll talk to the
Can you
learned
please
ASG.
Get back to my officer where it should be served.
My lord, my lord,
Lordship, I'm good.
my lord.
Lordship, I'm good.
17, my lord, I am for the petition. But here the petitioners are parents of the deceased son. But the deceased son was working as a constable in CRPF. But while he was in service, he made an accident, he expired. But he was then married. But the wife got second marriage. But I have annexed a copy of the registry of the marriage at page 33. And as she got a second marriage, so she does not fall within the, as a wife of the deceased son.
You know, there are now liberalized rules, and why have you not made the wife a party?
The-
Why have you not made the wife a party? She is the affected party.
because she already got second marriage, she left family, she got married. And I have annexed that marriage certificate at page.
You have to make her a party, Ashu. How can you get an order behind her back? And anyway, the rules have been liberalized now. The
Even
leave as prayed for to bring the private respondent on record, to bring the wife of the deceased son of the petitioner.
No, deceased son. Deceased son, wife.
I have said. Are you not hearing? On record is granted. Full stop. Next, necessary and amendments may be made to the cost title, full stop. Upon making the necessary amendments to the cost title, a copy of the writ petition will be served upon the added respondent and a proof of service be filed on the adjourned date of hearing, full stop. Let the matter appear for further consideration under the same heading motion, bolded, on June 12, 2023. Bolded, motion tar bolded, server copy. New motion হিসেবে এটা appear করবে on the new motion. It will appear as new motion.
May it be done at right now.
Yes, yes, that now.
According to the CCS pension rule, my lord, even after remarriage, that wife
Yes,
is.
I
yes,
have
yes.
told him already. He will look into it and
Yes,
come
yes.
back.
My lord, I beg to appear on behalf of the
So Mr. Ujjalre is appearing on behalf of the petitioner. He is on leg at court room number 4. Lordship, but humbly praying for not today.
All right, not today.
Grateful, Lordship.
I am the respondent 225.
My application, my lord,
Yes.
my affidavit of service. First matter is the petitioner father was an employee of Bongio Gramin Bank at Malda.
Yes.
While in service, he expired. Then petitioner's mother made an application. That is in 2017. March 2017, he expired. Thereafter, in 2017, September, she made an application for compassionate appointment to any of the family members, to his 2 sons or any of them. Now, that application was pending since then. And every time it was said that the matter is pending, one matter is pending to decide on the compassionate appointment before this honorable court. That was decided. I have annexed the order also, my lord, by my lord Justice Mantha in 2019. And thereafter, this application was made. In the meantime, he passed the honors. He has been passed the graduation, and this application is made if the respondent bank can consider for compassionate appointment. Because there was a dispute whether the notification of the Navadas came into effect in 2019 and he expired in 2017. That was the dispute, and that was resolved by the Honorable Justice, order of the Honorable Justice Mantha. They can only consider my mother's application.
তারপরে judgment গুলো দেখেনি না?
না, তারপরেটা আমি জানি না। আছে তো?
বলছি।
I don't know whether the order of my Lord Justice Mantha has been challenged in the higher forum.
মালিক থেকে
Yes.
My lord. My lord, the father of the petitioner died on, my lord, the 23rd of March 2017. On that date, my lord, there is no scheme for this Bongyo Gramin Vikas Bank. No scheme for
Have you considered Justice Mantha's order?
My lord, that was challenged before the Honorable Division Bench. That was reported. And thereafter, my lord, the Division Bench restricted this matter for this case only, that cannot be treated as a general principle. My lord, this is the Division Bench order, my lord. It is reported in, my lord, I am preferring appeal of this matter, my lord. 2022 Supreme Cal 832. My lord,
citation taken? Citation.
ওই সেম যেটা মান্থার ঘরে ছিল চিফ ম্যানেজার বঙ্গীয় 2022 সুপ্রিম ক্যাল 832
Supreme.
so my lord, last page, my lord, after affirming the order of this Justice Mantha, this court, the direction passed by this honorable single bench as affirmed by this court stand restrict to the facts of this case and cannot be treated as to be in the matter of general principle. This is the Shubhajit Bayan case. And thereafter, my lord, the order of the Supreme Court has came into the light that the...
Please read from before, in the light of the above findings.
Yes, my lord.
Please read from there.
Yes, my lord, but this is restricted to only the case of Shubhajit Bayan only, my lord.
It is not stated, it cannot be treated as a precedent.
The directions passed. Wait, what are the direction passed? So where is the scheme? You have the scheme?
Yes, yes, ma'am. I have the scheme, ma'am.
It has accepted the reasoning of the single bench.
My lord. Thereafter, my lord, the Supreme Court judgment has come in 2022, my lord, where, my lord, the date of death is to be considered.
Yes. But you have to understand the reasoning of the single judge.
Yes,
The
ma'am.
single judge is saying that it will, the date of the death prior to 5 years, that is the cutoff.
Yes.
Up to that date has to be considered.
Yes, my
Now,
lord.
this is a scheme of 2019.
Yes, my
The
lord.
date
Then
of death is 2017.
in 2014 should be from 2014.
You have to consider the representation in terms of the coordinate benches order.
And my lord,
The 5 years.
8.2, you take me to 8.2 first.
yes, my lord.
Bank can consider request for compassionate appointment even when the death or retirement on medical grounds.
Please take, where is 8.2?
Lordship, kindly come to page 20 of my application. There's the scheme is quoted by my Lord Justice Mantha.
No, no, this is the entire scheme, my lord.
Real estate even 5 years back.
All right.
And my
Where is your representation?
Page 17.
my lord, one thing, my lord, the representation is
My
maybe
mother.
by filed by the phrase because my lord, it is not in the form also. And
All right.
because
Now, the petitioner's father died in harness on March 23, 2017 as an assistant manager of the Bongyo Gramin Vikash Bank within bracket BGVB, bracket closed, full stop. An application for compassionate appointment was made on September 5, 2017 by the mother of the petitioner for appointment of any of the family members on compassionate ground. First, the said application has not been considered till date. Full stop. Next. Learned counsel appearing on behalf of the petitioner submits that the prayer of the petitioner for compassionate, the prayer of the petitioner's mother for compassionate appointment may be considered, and the petitioner may be appointed by BGVB, full stop. Next. Mr. Ghoshal, learned counsel appears on behalf of the respondent stroke BGVB and submits that no scheme was applicable for compassionate appointment in 2017. Full stop. In 2017, the time when the petitioner's father died. এইভাবে করুন on ওই ডেটটা দিয়ে দেবেন on March 23, 2017, the date of death of the petitioner's father. Full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court finds that by an order dated March 15, 2021, passed by a coordinate bench in WPA 3116 of 2021, within bracket Shubhojit Bayan versus Union of India and others, bracket closed. ওটাকে বোল্ডে করে দেবে ভেতরে ব্র্যাকেটের ভেতরে একটু। It was held that the scheme dated March 6, 2019 was applicable to an employee who died 5 years before the implementation of the said scheme. Full stop. The coordinate bench referred to clause 8 relating to time limit for considering the applications for compassionate appointment. Full stop. এইখান থেকে না clause 8.2 of the said scheme reads as thus. করে reproduce করে দেবেন যেখান থেকে যেখানে অবধি করেছি, italics insert. Next, the said order of the coordinate bench dated March 15, 2021 was carried in appeal. Full stop. Carried in appeal being FMA number 1226 of 2021. Full stop. The Honorable Division Bench held that the scheme for compassionate appointment was applicable to the claim of the writ petitioner. Full stop. Even in that case, the father of the writ petitioner died in 2017 prior to the scheme coming into force in March 2019. Full stop. The Honorable Division Bench was of the view that the coordinate bench correctly noted the provisions of the scheme and extended the coverage of the same, since the father of the writ petitioner died within a period of 5 years prior to the implementation of the scheme. Full stop. Next. However, the Honorable Division Bench was also of the view that the provisions of 8.2 have to be considered before such appointment was granted. And clause 17 within bracket III were also to be considered conjointly. Full stop. Conjointly. Full stop. Clause 17.3 reads as thus. Next. In the light of the discussions above, this court is of the view that the application for compassionate appointment should be considered by is of the view that in the event an application is made in the appropriate form within 2 weeks from date by the petitioner, then the respondent number 4.
No, my lord, 3. As per the scheme, 3 is the my lord authority.
The general manager.
General.
Then the general manager stroke BGBB stroke respondent number 3 or any other authority delegated by him will consider the case for compassionate appointment of the petitioner. Full stop. Next, in considering the prayer for compassionate appointment, the order dated March 15, 2021, passed in WPA 3116 of 2021, and the order passed by the division bench in FMA 1226 of 2021, dated April 13, 2022, will be taken into account. Full stop. Next. The application of the petitioner will be disposed of by a reasoned order within 6 weeks from date upon personal hearing to the petitioner. Full stop. A reasoned order shall be communicated within 2 weeks of passing thereof. Full stop. Next. With the directions aforesaid, WPA 9753 of 2023 is disposed of. Bold it, whatever it is. Next, since no affidavits, server copy, certified copy.
Well, within 6 weeks from the date of submission of the form,
Within 6 weeks,
from the date of submission,
you have been given 2 weeks. If you give
Weeks.
to supply
after
within
6
2
weeks.
weeks, then after that 6 weeks.
6 weeks.
You can take it back later. Once he finishes his
My lord,
typing, you
sec-
can take back the rules. later.
Second half, my lord, this type of matter are available before you lot 2 matters. I am there.
That is all right. Let the rules be there.
Yes, yes.
After he finishes his typing, then.
Smile.
I'm grateful to you.
I'll take it in second half. Leave it alone.
Yes.
Yes, my lord. Here, my lord, in 1990, I got the compassionate appointment. If you lordships kindly come, page 28. This is the service record of my father. After death, I got the compassionate appointment. This document of 1987, page 28, my lord. Majdi Bibi is my mother, now deceased. Rahman Mia is petitioner before your lordships. Rabida Khatun is, my lord, daughter of the deceased employee. Now, thereafter, my lord, in 1990, page 29, this is my appointment letter, my lord. I got the appointment and till date I am working in ECL. Thereafter, my lord, in 2022, I have annexed the other documents in support of my case, a training certificate, etc. And page 35, if your lordships kindly come. This is the service record of the writ petitioner. Page 36 is relevant page. Gulsen Bibi, wife of the writ petitioner. Kumari Khatun, daughter of the writ petitioner. Akbar, son. Majdi Bibi, mother of the writ petitioner.
Yes.
Thereafter, my lord, my employment has been processed throughout my mother. In 2022, my mother has died. Thereafter, in 2023, a charge sheet has been issued by the ECL on the ground that I am not the son, but son-in-law of the deceased employee. Now, if you also kindly come, page 38. There are 3 grounds of challenge of this charge sheet. First is delay, unexplained delay. I have the authority to say, my lord. My lord, serial number 3, he is informed that an inquiry will be held only in respect of the charges such and such. So, my lord, before reply to the, my lord, charge memo, they have opined that the inquiry will be held in the charge sheet.
No, that is no.
Yes, very well, my lord.
What
It's a
is-
very minor defect, very well. Thereafter, my lord, in the article of charges, they categorically said that I am not the son, but son-in-law. In NCWA, son and son-in-law having no, my lord, difference in respect of the compassionate appointment. Now, in the charge sheet, if your lordship find that there is no explanation of delay as to why 33 years has already been lapsed to issue the charge sheet. Because by this time mother has died, all witnesses have died, those who have certified and given surety at the time of my employment. That this is the one ground. Another ground, my lord, if you will kindly see who has issued the charge sheet.
No, what is, why theft, fraud, dishonesty?
Theft, there is no question of theft, no question of dishonesty. Because compensation appointment, they have processed, police verification, etc. has been conducted in the year 1990 before.
Because they are saying that you have committed misconduct under 26.1, 26.9.
Yes, so this is
Why
there.
all this?
This is there because 26.
False information regarding one's name, father's name, qualification.
So, my lord, in the year 1990, I have got the employment. 33 years has already been lapsed. Now they are saying without any explanation of delay as to why they have, my lord, issued the charge sheet after so many years. 33 years. Mother has died in 2022. I have authority to, my lord, I will show to your lordship the Supreme Court judgment on this, my lord, particular point, my lord.
Yes.
Now, if you also kindly see another point of challenge, page 38, who has issued the charge sheet? Charge sheet has been issued by the agent of the colliery. Now I have also annexed the rule. Page, my lord, 57. This is the revised delegation of power. Who can issue the, my lord, initiate the disciplinary proceedings in respect of the charges. Page 57, my lord. Now relevant portion, my lord, if your lordships kindly come, page 59. Left hand side, nature of power. My lord, and right hand side, CGM, GM and area. Next, my lord, agent.
Yes.
Agent. Now, kindly come, next page. Sorry, page 61. Disciplinary action, left hand side, in respect of the employees for whom he is the appointing authority. First thing, my appointing authority is, my lord, the chairman cum managing director of the company. Now kindly come right hand side. Full power, second right hand side, my lord, at top of page 61. Full power, this is the column of agent. Full power to take disciplinary action except dismissal against wage board employees under his administrative control and in accordance with the prescribed rules standing order. So at best, my lord, the charge sheet can be, my lord, these penalties or, my lord, these alleged offences can be, my lord, inquired upon only for the purposes of minor penalty, not for the major penalties. Because agent has issued the charge sheet, this is their rule. Now they cannot proceed for, my lord, major penalties.
Why not?
Because kindly see power.
Yes.
Power to take disciplinary action against except dismissal against wage board employees.
Yes, everything except dismissal.
Except dismissal.
Yes.
So-
there are various other major penalties apart from dismissal.
No, here, my lord, this rules is, my lord, different, my lord. Here, major penalty is only dismissal. Penalty is only dismissal. Dismissal or termination, my lord.
This is the old
Except,
rule. No, you say.
Except
This is the old
dismissal, let the continue. I have no difficulties. Now, this is the main 3 points. One is appointment of the inquiry officer. Your lordships may take or may not. Delay, main point. My father declared my name in the service record in 1987. My mother processed the employment. Mother, my lord, died in 2022. Thereafter, after 1 year, after 33 years, my lord, they have, my lord, issued the charge sheet. I will be highly prejudiced by reasons of delay. My lord, if your lordships kindly come. The judgment reported in 2005, volume 6, SCC, page 636. Paragraph 7 and 11. Page হচ্ছে 636. Here, my lord, the disciplinary proceedings were started after 10 years in this judgment. The very same ground has been specifically raised in this appeal before this court, wherein it is stated that the delay in more than 10 years in initiating the disciplinary proceedings by issuance of the charge memo would render the department proceedings vitiated, and in the absence of any explanations for the inordinate delay in initiating such disciplinary proceedings of issuance of the charge memo would justify the prayer for quashing the proceedings as made in the writ petitions. And finally, the Honorable Supreme Court quashed on the ground of delay.
Yes.
No, my lord, another judgment of this Honorable Court Division Bench judgment, my lord. 2008, volume 1, CHN, page 746. Paragraph 7, my lord. Page 746. The learned senior counsels of the appellant, however, submit that on account of the aforesaid delay in initiating the disciplinary proceedings, appellant hearing is bound to suffer serious prejudice, since the vital witnesses, namely the mother of the said appellant, here also same, my lord, expired before completion of the disciplinary proceedings. The learned senior counsels also submits that the mother of the said appellant was the best person to disclose the materials relating to the submissions of her resignations before the concerned authority during the period in questions, and due to the delay in initiations of the disciplinary proceeding, the same said mother of the appellant expired before the completions of the proceedings. Now the division bench has quashed the entire charge sheet on the ground of delay, because delay prejudice, highly prejudice the delinquent employee. No, my lord, this is my submission.
But so far, Mr. Ghoshal's submission is concerned. Once he's challenging the charge sheet, on the other hand, he's saying that he has no problem if it goes without imposing any major penalty. This is his submission, my lord. Now, my lord, so far the major penalty, I'll try to satisfy your lordship. Major penalty is concerned, my lord. This is not the stage where he can agitate that, because no penalty has yet been imposed. If I had imposed any penalty, he would have come and said, no, I have no power. Whether I have any power or not to issue the charge sheet, I will satisfy your lordship. Now, first of all is that this rule which Mr. Ghosh has cited as annexed revised delegation of power, this is no more in existence. May I hand up the new one, my lord, of 2004. না কপি নেই এখন একটাই আছে লিখছি this is of 2004. দেখো this is of 2004, my lord. This is the delegation of powers, my lord. If your lordship kindly takes up, my lord, the issue has been, my lord, the second paragraph. The issue has since been examined at length and in terms of the power conferred upon him under section. My lord, I have annexed the typed copy, my lord. I'm reading from typed copy, my lord. Second paragraph. The issue has since been examined at length and in terms of the power conferred upon him under section 2.3 of the certified standing orders of the company, the CMD, the chairman cum managing director, ECL has accorded approval that in different establishments of the company, the undernoted authority of the establishment should be treated as competent authority of the company within the meaning of certified standing order of ECL, and they shall function accordingly. You are hereby directed to collect your full and final dues after observing all necessary formalities such as vacating the quarters, if any, obtaining no. Then competent authority. In respect of areas of ECL, the chief general managers, the general managers, project officer, colliery managers. Now the project officer, agent is a project officer. Managers will be the competent authority to exercise the powers for implementation of the provisions of standing orders and taking disciplinary action under the provisions of certified standing orders. So the agent has the power. Agent has the power. He's the
2000 also the agent had the power.
has the
Apart from
power.
dismissal, all powers.
But now in 2004 also, my lord, he has the power. So Mr. Ghosh stand today that it has been issued, the charge sheet has been issued without any authority.
Power. In 2000 also the agent had
Yes.
the power. In 2004
Yes.
also the agent had the
2004
power.
is specific. There is no embargo on his power, that he cannot give the major penalty, inflict major penalty. He can inflict only minor penalty. And
Your submission is that that will be decided at a later stage.
later stage. And so far, my lord, delay is concerned, my lord. Here I have something to submit, my lord. There are many things, my lord. I can, if I do not want to take much time of your lordships by going paragraph wise. But my lord, this matter is to be taken up with another matter, my lord, which is appearing at item number 144 of today's list, my lord. My lord, Muhammad Rahman Ansari, it's WPA number 4101-2023. It once appeared before the Honorable Justice Raja Boshu Chaudhary, where it was released for want of determination. Now it is appearing, my lord. It just appeared today only, my lord. I have seen that today only. Because this Rahman Ansari, he has filed this writ petition. He made a complaint to us in 2022. Several letters he had issued, on the basis of which, after getting that, we made a vigilance. We accorded a police complaint, my lord, which is in the imputation of charge.
Well, I am not aware of that.
Yes, yes, you are not aware of. I'm just addressing the court. I will tell you, my lord. On the basis of this application, my lord, we made a vigilance, my lord. Now, vigilance asked the concerned police authorities to give a report. Now, based on the police report and other documents, if your lordship kindly comes at page 40, imputation of charges, my lord. Imputation of charges. Page 40, my lord. 1, 2, 3, my lord. Third paragraph, that Sri Rahman Mia claimed employment as son of late Charku Mia. So this Charku Mia was the employee, and given false documents and false declaration during the time of process of his employment that he is the son of late Charku Mia, but he is actually Islam Ansari, Islam Mia, son of Gullu Mia. This may be our allegation. This may be our allegation, and he is not suspended. And he is onto his job, my lord. That during investigation, it came to notice that the person working as son of late Charku Mia had married with Srimati Gulshan Bibi, daughter of late Charku Mia. Therefore, Islam Ansari is actually son-in-law of Charku Mia and somehow managed to get employment impersonating Rahman Mia, the only son of late Charku Mia, who was minor in the year 1990. That from the police verification, also, it has been proved that Sri Rahman Mia is actually Islam Mia, son of Gulu Mia, and he is son-in-law of late Charku Mia. Sri Islam Mia got the employment being faked as Sri Rahman Mia, who is originally the husband of Srimati Gulshan Bibi, daughter of late Charku Mia. That it is come to the knowledge of the authority that Sri Rahman Mia is not the son of late Charku Mia. Sri Rahman Mia has produced fake relationship on the basis of forged documents and somehow managed to get the employment in ECL, taking advantage of the NCAA4. These are the charges, but leveling charges do not prove it, my lord, just does not prove it. So he may be exonerated. It's not that we have level charges, we are initiating a disciplinary proceeding. It means that he will be punished. It's not that. He may be exonerated. Why is afraid of facing the trial? Why? Now, my lord, kindly turn to the next page, my lord. These are the documents. Obviously, he has the right to get the documents and he will get it. The inquiry proceedings has not yet been started, my lord. He will have the right to cross-examine in the witnesses of the management. Police verification report, voter list, my lord, kindly see. voter list, general panchayat election 2022, district Giridih, block Bengabad, Gram Panchayat, Chowpadi. Charku Miya was the resident of Chowpadi. So the Rahman Miya also. Appointment letter, copy of Sri Rahman Miya, Banshabali issued by Mukhya Gram Pradhan, Gram Panchayat, Chowpadi.
What is your explanation with regard to delay?
That's the delay, my lord, because we were not aware of. We gave it. Now in 2022 only, my lord, we came to know from this letter.
No responsibility, was there no responsibility on your part to verify the document?
We, in 1990, my lord, kindly think at that point of time.
In most of the matters, you are very vocal about delay. So what is the explanation?
Yes,
of
my lord,
delay
this
on
is
your
my,
part?
this is my lord. We in 1990, my lord, kindly think about the situation at that point of time. So in 1990,
Situation.
no, my 1990,
Verification of documents will be done today also. In 1990 also, in 1950 also,
no, my lord,
in 2000.
in 1990, there was no Aadhaar card, nothing at that point of time. Whatever documents he produced on the basis of, he produced
Did you not
documents.
verify? Because in so many matters you send for
My lord, at that point of time,
investigation, you send for
1990, my lord, it was basically it was not done at that point of time. Now, my lord, we were,
basically not done. That
was
is
not
why
done,
I
my lord.
want,
Now,
in
my lord,
this matter, I want Eastern Coalfields to really come up with
yes,
solid explanation regarding
yes,
the
my lord, in now, after getting in 2022, after getting this, my lord, kindly take up these two matters together, my lord. Because I have to answer this writ petition also. Because here also, my lord, they are claiming that this Rahman Ansari, he is claiming to be the son. He has annexed certain documents, my lord. Both the matters be taken up together. If your lordship directs me, then I will.
I'll post it after the vacation. I'll take up both the matters together. Mr.
Lord, I am not party to these proceedings and I am not aware. So, my lord,
Yes, you will be aware. He will serve.
my lord, in the meantime, copy me, sir, my lord,
Yes, my lord. A notification was issued by the respondent authorities for recruitment as ASTHA workers, ASHA workers, not accredited social activist worker, my lord. There, my lord, in the notification, 7 villages were specified in respect of which the recruitments were to be made. The first and foremost criteria, I'll come to the notification, my lord. The first and foremost criteria in the notification was those who are those who are applying for recruitment must belong to the villages which are mentioned in the said notification. My lord, I apply. I fell under one of the villages called Mahishda. I fell under one of the villages. I applied. I was called for Viva. Then, my lord, I don't receive any other communication from the authorities. Then, my lord, I come across a letter where a letter has been issued by the authorities to another candidate who does not belong to any of the villages mentioned in the notification, saying that she has been recruited. She is in the process of being appointed as an ASHA worker under that specific notification itself. But I am challenging private respondent number 5. But I have served one of the affidavit of services here. But I am challenging that letter issued by the respondent authorities, where it is ex facie devoid of merits and it's contrary to the notification. Kindly, when it comes to the
Who is
notification,
appearing for the state?
I appear for the state now.
You're appearing for the
Yes.
state.
kindly when it sees the notification at page 16. When it kindly sees it's all in Bengali, the Abedonkari Joggota, if your lordship has.
Yes, yes.
At page 16, আবেদনকারী যোগ্যতা, the first clause, প্রার্থী যে গ্রামে আশা পদে নিয়োগের জন্য আবেদন করবেন তাকে সেই গ্রামের স্থায়ী বাসিন্দা হতে হবে. That is the fundamental criteria. Now, lordship will see at page 17, these are the villages in respect of which the notification has been issued.
Yes.
Towards the middle, name of the village where vacancy is being proposed. Lordship has found that. In these villages, I fall under Mahishda. It is wrongly written as Mahishda. It should be Mahishda. Mahishda, and the subsection is Demari on towards the left of this row. Now, the letter which I am challenging is at page 21.
Yes.
Letter issued by the Health and Family Welfare Department, Shomiti, find enclosed so-and-so of Additional Mission Director, Secretary of West Bengal, regarding approval of 7 candidates as Asha of Shohid Matongini block. Shohid Matongini block, it's the same block within which the village is situated. The concerned village is situated. You are requested to take necessary arrangements so that the procedure for engagement of 7 numbers of Ashas under Shohid Matongini block can be completed at an early date. Kindly, his mother turns over the page. At page 22, kindly see serial number 3. These are the approval of the candidates who had.
I have seen that.
Yes, serial number 3.
Hmm.
She is the respondent number 5. Yes, the document on which I rely on to say that this respondent number 5 does not reside in the village. The voter list, the election list. Kindly, sees page the voter list starts from page 28. Well, it's right hand side.
Yes,
Top.
I've seen.
Yes.
And I can't read what is written
The
on
name
top.
is Kakoli Bongal Dash.
That I can read on top. For which area is it?
This is
Dokhinpara. It is hardly
It is.
decipherable.
It's on the top left.
Yes, that is what is
But it
extremely
is not
difficult for
readable,
me.
Milord.
Or it's in my when it was drafted.
Right hand top. Milord, it is not readable, Milord, illegible.
That is what I am trying to tell him.
Yes. Oh, let's answer.
Kindly sees page number 26. It starts from page number 26. I'm sorry. Yes. On the left hand side, Pakuria Dokhinpara. Ongsher Bhag number o naam. Pakuria Dokhinpara, Pakuria Uttorpara. Under this, the respondent number 5 falls.
All right.
That is my
Yes.
Milord, admittedly, Milord, after interview, he was not called. Milord, that is, Milord, she was unqualified. Milord, his only challenge
that the respondent number 5 is not a permanent resident of that village. Your lordship, kindly come to page 17.
Yes.
And he is praying that he should be given appointment. Being
You
an
please tell me, as per the guidelines, how have you appointed respondent number 5? Please
So,
show me that.
for that matter, your lordship, kindly come to page 17.
Yes, I'm looking at 17.
Towards the middle, my lord.
Yes.
Third,
Yes.
Raghunathpur, your lordship got page
Yes.
17.
Yes.
Kamari,
Yes.
Mohisha,
Mohishda.
Mohishda.
Khatpara, and Pakuria.
Pada.
Have your lordship got it?
Yes.
And my learned friend claimed that he is not a resident of Mahishada, but Pakuria. Pakuria is also included in Raghunathpur.
Pakuria Pada.
Yes. So she belongs to Pakuria. So Pakuria also included.
Yes. All right, yes.
My instruction is, so far as this allegation is concerned, Pakuria, the page number 26 specifies Pakuria Dokhin Para, Pakuria Uttor Para.
Yes.
And
They
Bharat-
have said Pakuria Pada, so it will
Yes,
include
Bharat.
Dokhin, Uttor.
My instruction is, yes, Bharat, no, my instruction so far as that is concerned is Bharat, Pakuria Para, Dokhin and Uttor. They are all separate. And Bharat, so far as I am concerned,
Pakuria Pada is separate from Dokhin and Uttor.
Dokhin and Uttor, there are subdivisions and the Pakuria Para is separate. That is my instruction. Bharat, I had seen this. I had asked my client, my client is saying this is not the specific region which falls under the notification.
Let them file a report, Ashwin.
Very good.
After learned counsel appearing on behalf of the petitioner submits that the petitioner applied for engagement as an accredited social health activist within bracket ASHA, bracket closed Karmi, pursuant to an engagement notification dated August 31, 2022, full stop. The eligibility criteria for engagement of ASHA included the candidate having the candidate having to be a permanent resident of the same village stroke service area for which the engagement was sought to be made. Full stop. Next, the petitioner is a resident of village-Mohishda service area, Mohishda Hatpada, Pakuria Pada, subcenter -Demari, Gram Panchayat Raghunathpur Roman 1 district Purbo Medinipur. Full stop. It is the petitioner's case that the private respondent number 5 was not the permanent resident of the said village stroke service area for which she was selected by a memo dated January 31, 2023, issued by the additional mission director, National Health Mission, full stop. Next. Learned counsel appearing on behalf of the state respondent submits that the petitioner is a resident of Pakuria Dokhin Pada, relying on the voters list, full stop. He draws the attention of this court to the vacancy list, wherefrom it appears that the service area is Pakuria Pada, for which there was a vacancy for engagement of the Asha Kurmi. Full stop. Next. Considering the submissions of the parties and the materials placed on record, this court finds that justice will be subserved by directing the subdivisional officer Tomluk respondent number 3 to file a report on affidavit stating whether Pakuria Dakshin Pada and Pakuria Uttar Pada are included within the service area, inverted commas er moddhe Pakuria Pada, inverted commas closed, full stop. Let such report on affidavit be filed by June 23, 2023, full stop. Exception, if any, by June 30, 2023, full stop. Next. Let the matter appear under the same heading motion, bolded, on July 3, 2023, full stop. Serve upon.
And the affidavit of service be kept with it. All have been served.
But in this case, if I find that this is completely frivolous, please advise your client that this court will not take it kindly.
Yes, yes, my lord.
These kind of frivolous litigations,
Also a confusion I
one
had.
thinks that one can file to get sympathy of the court, this will not be
No
appreciated by
sympathy,
this
my
court
lord.
at all.
No sympathy at all, my lord. This is the instruction that I sought for, and this is on the basis of that instruction itself that this was filed. Later on, if it
High
comes out that
prerogative jurisdiction of this court, if this is the way it is going to be abused, this court will not be very happy about it.
I completely understand, my lord. If it comes out in the report that this belongs to the same area, then, my lord, I do not have any case when my instruction was false. Then I would have to, my lord, come to that.
I'll direct the district magistrate to take steps against the petitioner if it comes out.
Let's. Grateful.
Right. I am for the petitioner. My lord, paying for 1 day's accommodation on behalf of the state respondent. My lord, in this matter, Mr. Pinaki Dhol is appearing for the state and he is engaged in court number 39. 1 day's accommodation, my lord.
5th of June.
My lord, it's regarding the appointment, my lord, it will be too late, my lord.
Not today, pura rakho dekho. Kalke to returnable devo Thursday new motion nevo. I'm making it not today, it will appear on Thursday. Probably I'll take up new motions on Thursday, this Thursday.
Great, ma'am.
Say beg to appear on respondent number 6, my lord. May I please, my lord?
Authority.
But only one indulgence, my lord, before starting of the case, my lord, my client has only received the petition copy, not the annexures.
Who is the petitioner?
But I am
Why
for
are
the.
you not coming this side? Mr. Shamanto, please come this side.
Yes. Sir. I am for the copy incomplete.
Lordship, I am appearing in this matter on behalf of respondent number 5.
Yes, what is the case about?
My lord,
Yes.
it's a case, my lord. The husband is army officer, my lord, lieutenant colonel.
Yes.
My lord, out of my lord wedlock, my lord, a child has born, my lord, on in 2017. My lord, after that started to misbehave, my lord. Couldn't stay. My lord, a flat was purchased in the joint name of husband and wife. Now, my lord, to precise the my lord, the EMI has been stopped and bank has been insisted, my lord, to sale of the property. Number one, under SARFAESI proceeding. Number two, my lord, she is not getting any maintenance. Under the Army Act, my lord, there is a provision, my lord, that she should get the, my lord.
You have not received a copy.
I have received the petition's copy, not the annexed. I need the annexed. No, I'm sorry.
You are appearing for?
The husband, my lord, respondent number 6.
Yes. You are for the authorities, yes.
My lord will kindly have a look, my lord, to the provision, my lord. Section 90, my lord, I. Section 90I. I have made representations to everyone, my lord, once it was responded. Section 90, my lord. Section 90, my lord, subsection I. Has my lord got it?
Yes.
But I'm reading, my lord. Any sum required by the order of the central government or any prescribed officer to be paid to the maintenance of his wife or his legitimate or illegitimate child or towards the cost of any relief given by the said government to the said wife or child. But I have made representation. Now you'll also kindly see one representation I am showing at page 74. But it's to the, he is the appropriate authority, but General Officer Commander in Chief. But still then, my lord, nothing. Once they have said that it will be under process, but still nothing has been done.
Which page?
But at page 73, my lord, the representation. Page 74, I stand corrected. And my lord, the only communication for me, Army authority I got, my lord, is at page 54. It starts, my lord, from page 53, annexure P3. My lord will kindly take a look at page 53, my lord, bottom. Paragraph 3. In case the matter cannot be resolved amicably, the case for grant of maintenance allowance as per Army Order 2/2001 may please be processed. But thereafter, my lord, the Army authority kept silent. Then, my lord, next page.
I have read that.
Yes, 54, my lord, has read.
Yes.
So, my lord, under these circumstances, my lord, under the Army Act, my lord will find, but there is a judgment also in this regard, my lord, may I place it, that irrespective of any other thing, even though maintenance proceeding, whether it is pending or not, whether it is there or not, irrespective of that, my lord, the my lord, person concerned is liable to pay.
My lord, your lordship will kindly see. My lord will kindly come to paragraph 8 at page 671 of the judgment. Section 90I of the Army Act makes provision for deductions from the pay and allowances of an officer of any any sum required by the order of the central government or any prescribed officer to be paid for maintenance of his wife or his legitimate or illegitimate child in terms of Rule 193. The Army Rules prescribed officer for the purpose of Clause 1 of Section 90 is the Chief of the Army Staff or the officer commanding the army. But I have made the representation at page 74 to the officer commanding of the army. To give effect to the aforesaid provision, an Army Order 23 of 94, when it was an order prior thereto, instead thereof, Army Order 2 of 2001 has come into sets out a detailed procedure to be observed by the competent authorities before ordering for deduction of any amount from the pay and allowances of an officer on account of maintenance to his wife or to his legitimate or illegitimate child. Noticing that all personnel subject to the Army Act are legally and normally bound to maintain their wives and children, the said Army Order prescribes for procedure for grant of maintenance allowance after the detailed examination of a complaint from the wife or on behalf of the child. It provides that the power to grant maintenance under the Army Act are independent of the provisions.
So far the maintenance is concerned, there is no dispute, madam, she is entitled. That is, she will get. But
Why have you not processed under 23 and
there is there is a process to comply with by the wife. But I tell your lordship, my lord, previously there was a dispute and that was resolved with the intervention of the lady councillor. Now this time after this, my lord, the lady councillor, the authority again through the lady councillor called the petitioner. Yes, please come. This is my instruction is there. Please come and cooperate so that the matter can be resolved. That the petitioner is not cooperating. That is my instruction. And so far the my lord, other part is concerned. As of date, she is having the grocery card.
Let's look at page 54. It cannot be resolved, and that's why the colonel has requested the petitioner has requested to process her case for maintenance.
And I have got the narrative and supportive family therapy for 3 months. That she is not cooperating. This is my lord, one part, and the other part is, my lord, that there is a procedure, my lord, to claim by affidavit. She has to file an
Army Order number 23 of 94. You have to follow the procedure.
She has to file an affidavit before the proper authority, giving all the details, and that is provided in this regulations, my lord. Regulations manner Rule 5 and Rule 7, there is a procedure that she has to comply. Now, if your lordship kindly direct him to comply, we'll pay him.
Unless and until the petitioner is informed, she is not aware of all these things that this affidavit has to be given.
I have have only placed your lordship the last paragraph of the instruction. The full instruction is me, my lord. The instruction is, and so far the EMI is concerned, my lord, the flat has been directed to be demolished because this is unauthorized construction. That is why, my lord, the EMI has been stopped, and no use of.
Why are you submitting that?
That is my instruction.
Why are you submitting? It is the private respondent.
That is here, my lord, that is in the also in the. That has come out in course of joint council.
So which provision are you referring to?
Rule 7.
Five, starting from 5 and 7.
কি রুলটার নাম দেখি
Five and seven.
আর্মি অর্ডার এটা তো নেই, এটা পাবো কোথায়?
I have,
Kindly come to clause again to get it very clear instructions. And 91 has to be read with 193 of the army rules.
এটা দেবে, কপি করে নেবো আমি।
no doubt she is entitled.
You make a proper application.
My lord, unless and until I am instructed that this is the affidavit.
But one thing is very important, because 91 has to be read with 193 of army rules, which clearly says that the chief of the army staff or the army commanding officer is the in charging authority. Next, my lord, has to come to army orders. What is, my lord, before your lordship? It clearly states that it is established the wife is living in adultery, that is not, or is without any sufficient reasons she refuses to live with her husband. But I have given a reply to my wife stating that I want to live with you. Thereafter that, on 9th August 2022, thereafter also she is not staying with me. She has her own demands. But thereafter also, if maintenance to be, till date I am paying her 15,000 rupees. Till date I am willing to take her back, but she is not cooperating with the, not in fact with the authorities also. So my lord, that is the main scenario concern is now there.
I subject to correction by your lordship. My lord. My submission on the learned advocate for the husband and the petitioners to sit together, my lord, so that the matter can be resolved. My lord.
How can you say that?
My lord, because my lord, to resolve the dispute, my lord, they are not coming to the lady council. Let an efforts be made. My
You
lord.
have to see whether there
Yeah,
are
only the-
sufficient reasons.
Yes.
This
that
is for you to investigate whether there are sufficient reasons for them to
That is-
stay separately or not. You are not to advise whether they will stay together, not stay together, what they will do. You will just see whether there are sufficient reasons for the petitioner to stay separately or not.
That is there.
My lord, unless and until the authority asks my client, my lord, that this affidavit has to be given or this has to be given, because he doesn't possess, my lord, the army order as is being there. Unless and until it is there, my lord, she cannot do that. Once, my lord, a telephone was made to go to Binaguri. My client categorically said that my past experience is very much bitter, as and when
I am not interested.
No, as and
I am just
said-
not interested.
Yes, yes. Yes, my lord.
The thing is, I will direct them to supply you with the necessary format.
Yes,
They will supply,
Yes,
you will make an application within a particular time,
yes, my lord.
and then I'm keeping it pending.
Yes, as my lord pleases. As my lord pleases.
But a copy may be served.
Copy of the writ petition. A copy of the writ petition is directed to be served along with all the annexures on the private respondent number 6.
Phone number
Full stop.
May I hand up your lordship the full instruction received by me, a copy?
Yes. A copy of the instructions handed over in court today by the respondents number 1 to 4 are retained with the records. Full stop. Next, the petitioner is the wife of the private respondent number 6. Full stop. The private respondent number 6 is a lieutenant colonel.
Now he is a major.
The private respondent number 6 is working as a major in the Binaguri military camp, comma,
I want to see instruction.
district hyphen Jalpaiguri. Full stop. The petitioner prays for maintenance from her husband in accordance with Section 90 of the Army Act, 1950, full stop. Next, it is the grievance of the petitioner that
With my lord's leave, my lord, put number 6, Madam.
despite being appraised of the marital discord between the petitioner and the respondent number 6, the authorities concerned are not taking any steps for deducting the pay and allowances from her husband's monthly salary and not handing over the same to the petitioner. Full stop. Learned counsel appearing on behalf of the petitioner refers to a communication dated October 20, 2022. To show that the petitioner has intimated the authorities concerned that the compromise that was earlier arrived between the parties in December 2018 has now become null and void, and the petitioner has paid for payment of maintenance. Full stop. Next. Learned counsel appears on behalf of Union of India and submits that though it is not in doubt that the petitioner is entitled to maintenance, but certain steps have to be followed for deductions to be made from the pay and allowances of the respondent number 6. Full stop. Applications have to be made in necessary format for processing the maintenance order. Full stop. Next. Learned counsel appears on behalf of the respondent number 6 and submits that a copy of the writ petition has not been a copy of the writ petition along with annexures have not been supplied to his client. Full stop. Next, considering the submissions of the parties and the materials placed on record, this court is of the view that the respondent number 4, the commanding officer, should intimate commanding officer or any other authority delegated by him should intimate to the petitioner as to the procedure that is to be followed by her for a maintenance order. Full stop. The said exercise will be completed within 3 weeks from date. Full stop. Upon the petitioner filing a prayer / application for maintenance, the authorities concerned shall initiate proceedings for grant of the same upon complying with the necessary formalities within 3 weeks of receiving the said application, full stop. Let the matter come up for further consideration in the monthly list of July 2023, bold it, under the same heading motion. Bold.
Only
Full
one
stop.
Lashmi-
Server copy.
I gather that their process has already been, they have already issued the process because the conciliation is going on. Next date has, last date
ওনাকে
was on
ওখানে
March 20.
যেটা বলেছি যে submits that private respondent এর হয়ে, he submits that.
Lashmi, may I submit on behalf of
Process
respondent
of
number?
conciliation is
Going on.
the process of conciliation between the petitioner and the respondent number 6 is being carried out. Wife says there is no conciliation, husband
There is
says
a-
there
there is
is
order, madam.
conciliation.
There is also.
Yes, what do you want to say?
Lashmi, bank is not a necessary party in this
All right, you
situation.
give your appearance now, you be there. On the next date, I'll consider your.
Lashmi, I was praying for
Well,
expunging
yes, just
respondent
one-
number 5, Lordship.
The private respondent number 6 says that the only the copy has been served, not the annexures. I will serve the copy, but the thing so is that everybody else served with the envelope with 200 grams of articles.
Anyway, you serve him.
Well, how-
What is the point in taking,
How the
making an issue out of it?
no,
He wants
how-
another set of annexures, please give him another
I
set of
will not.
annexures.
I say no, I will, but what is the argument being made from the bar? I can understand that. We are sub filing.
Orderটা নিয়ে নেন। এটা execute
Good.
করুন।
Yes, your Lordship.
Give the question.
Your Lordship, in this matter, I am for the petitioner.
Yes.
I'm for
Yeah.
the respondent number one.
Your Lordship, this instant petition is to put an stay over the departmental proceeding when the criminal proceeding is already going on. With the permission of your Lordship, I will just narrate this story in brief. The petitioner is an ex-serviceman. After serving 20 years in Indian Navy, he joins the Andhra Bank. I'd like to Andhra Bank, firstly. So, and he served in Indian Navy in a very exemplary manner, getting 3 good conduct badges, and even he got the proficiency award as well. When he joins the Andhra Bank at Ulhasnagar in the year
2015. July
2015. Yes, your Lordship, 2015. And after that, from 2015, he shifted to he comes to the Chandanagar. Was transferred on 27 August 2018. Everything was running smoothly. Then on 5 June 2021, the respondent number 3 as assistant manager joins the bank, and there is some dispute arises because he was an ex-serviceman, and as per the allegation that he was passed some comment that you are not fit for the cashier duty, you are just fit for the guard duty, you have come under the quota and all that. So there was some rift created between the respondent number 3 and the petitioner. After that, the petitioner was awarded a punishment for disobedience, because since he was an ex-serviceman, I really feel sorry to say that it was very difficult for him to accommodate in that lobby work culture. And but this now coming to the this instant petition, your Lordship, on 6/10/2022, allegations are there that the petitioner, he assaulted, and subsequently an FIR was lost. Your Lordship comes to page number 22 to 24. Typed copy 22A. Your Lordship kindly comes to typed copy 22A.
and criminal proceeding started.
Yes.
Now, in the meantime, when he was in the judicial custody, Your Lordship, he was in the jail custody till 25/11/2022. A SOCOS was issued. Your Lordship kindly comes to page number 31. When he was already under the judicial custody, in the jail custody, that SOCOS was issued. So the petition.
Was issued on?
SOCOS was issued, page number 31, Your Lordship, 15/10/2022.
Yes.
Then investigation started, and this investigation was completely arbitrary, based on the same criminal charges against the petitioner. The petitioner sends the representation to put an stay over the criminal proceeding. Subsequently,
Did you reply to the show cause?
yes.
Did you reply to the show cause?
Yes, Your Lordship, it was replied. The written brief, that is on the page number 35. Your Lordship kindly comes to page number 35, and it was replied. Your Lordship comes to page number 44.
No, this is a reply to the charge sheet.
Charge sheet.
Did you
Yes, Your
reply
Lordship.
to the show cause?
Your Lordship, he was already under the custody when he received the SOCOS. So he has
That cannot be, because in your writ petition, you are saying at page 6 that you have joined on 6th of October, and this show cause is dated 15th of October.
6th till 25th of November, he was in the custody, Your Lordship.
So what is the meaning of paragraph 19?
Paragraph 19. No, paragraph 19 is, Your Lordship, after paragraph 19.
From when to when were you in custody?
On 6th October only, Your Lordship. On the same day of incident, FIR was lost and he was under the custody. My instant petition is before Your Lordship, that till the time I am relying upon certain judgments. Kindly.
First, you have to tell me the facts of the case properly. Then only I can appreciate the judgment. You tell me from when were you in custody? I'm asking you a question. You have not written that in the writ petition.
Your Lordship, this FIR was lost on the same date, that is 6th October.
Maybe, but from when were you arrested?
On the same day he was arrested, Your Lordship.
Where have you stated that?
That FIR copy I have already annexed.
I have understood that. Where have you stated that in your writ petition?
Mhm. 17. Your Lordship, if comes to page number 29.
Yes.
From there, it is clear that he was already there, Your Lordship. Right. So, Your Lordship, I am relying upon certain judgment. My instant prayer is that till the departmental proceeding, till the criminal case is going on, that the department to put an stay over the departmental proceeding. I am relying upon certain judgments, and even if he is tried by the learned court for the criminal proceeding, the bank has always the option that as a consequential penalty, they can take further action. But till the time criminal proceeding is going on, so they should put an stay. So subsequently, a legal notice was also issued, and agreed by this, the petitioner filed this instant writ petition. So they have taken the considered the point of past record of the individual, that he was always creating nuisance in the bank. He was always arrogant and disobedient. So my prayer before Your Lordship is that if they are taking the past record of 2 years, okay, they should also consider the past record of the 20 years, last 20 years, where he served the nation, where he was as a submariner. Out of 100:1 is the ratio of the submariner. Almost, if we go for the selection of the submariner, out of 100:1, it is in general.
How is that relatable to you hitting someone?
No,
with
it
a
is not.
chopper on your
No,
head?
no, it is not.
How can it be relatable? How many medals you have received? Can it be equated to
No,
hitting
no,
someone
no,
on the
no, no,
head?
no. Absolutely not.
And that to a lady assistant manager on her head, hand, you hit that person with a chopper and then you say that I have received medals.
No, absolutely not. Absolutely not. My instant prayer before Your Lordship is that I'm not justifying that before Your Lordship. My only prayer is that till the time criminal proceeding is going on, they should put an stay over the departmental proceeding.
I am trying to read the charge sheet. Please allow me 2 minutes. Yes, Mr. Dev.
Lordship has gone through the charges. Lady officer has been hit it with the chopper and all these things at the strong room. That has got, this is a departmental proceedings, as Your Lordship knows better than me. It has got a
Not
difference.
better than you. In many of the cases, you make that submission, not better than you. Yes. Tell me.
And I will just say, so I think my learned friend will rely on M. Paul Antony.
Yes, he has already relied on that.
Yes, M. Paul Antony doesn't have any matter of applicability. I will show two judgments, one of 2022 and one of 2018. No, both are of 2000. No, one of 2022 and one of 2018. So far as my learned friend's client is concerned, he belonged to workman category. He is a cashier in the bank. In industrial matters, also the Honorable Supreme Court has said
the standard of proof are different because the proceedings in criminal proceedings is against the state, and punishment will be on different footing than that of the departmental proceedings. So in 2022, dealing with the judgment of Impol Antony and thereafter all the cases, the Honorable Court has been pleased to hold. Lordship, kindly take the trouble. 2022. 2022 SCC online SC 114. Lordship, kindly take the trouble to consider para 10. There should be, may I place it? There should be no ambiguity in the law on this subject. A departmental proceedings is a different from a criminal proceedings. The fundamental difference between the two is that where a departmental proceedings, a delinquent employee can be held guilty on the basis of preponderances of probabilities. In a criminal prosecution has to be proved its case beyond reasonable doubt. In short, the difference between the two proceedings would lie in the nature of evidence and the degree of its scrutiny. The two forums therefore run at different levels. For this reason, this court has consistently held that merely because a person has been acquitted in the criminal proceedings, he cannot be ipso facto reinstated in the service.
But in this case, at the very threshold,
Lordship.
are the charge memo, the allegation in the charge memo and the allegation in the charge sheet, are they not different?
Lordship, kindly consider one thing.
I am asking you.
No. Yes, but
The allegations in the charge memo are of insubordination and all that.
yes,
And the charge sheet in the criminal proceeding is for something completely different.
yes, certainly. Assaulting and all this.
Paul Anthony proceeded on the basis that the
Same
same set of charges.
Yes. This is a disciplinary proceedings on insubordination. There is
Lordship.
insubordination, then acting not within the parameters of a disciplined employee. These are the things. It has got nothing to do with the criminal case. Because criminal case.
With it on the next date of hearing.
Lordship.
I'll continue with it on the next date of hearing. It will take some time to dictate.
Yes, and Lordship, the judgment of on ID, because my learned friends,
Ashun.
I ought to have raised objection regarding maintainability of the case because
In this matter, I am appearing for the petitioner.
I appear for the Union of India with Lulu Mukherjee. Yes.
This is that matter, my lord, where
Yes.
the pensionary benefit. My lord has earlier occasion directed them to raise some document.
Lordship, we had contacted the concerned officer, but we have not yet got any status report from that end, whether the wife, actually the rules require the wife to apply before. Yeah, and to make a declaration. To make a declaration. Yes, so I Because asked the you to take declaration- necessary instructions with regard to that. Yes, the declaration that is to be made, whether she's made it to the proper authority. My Yes, learned that I friend- have asked you to take instructions. Lordship, I have not yet got the instructions from the proper authority. I have sent a signal, but he has not responded back as yet. That is the administrative authority of Purba Bardhaman. We have, but we have not yet received that. Whether my learned friend could.
So I'm just
show
adjourning it. Let it appear on the 20th.
of June. Lordship.
Let it appear on the, and Mrs. Alam, what happens, because in some of the matters, union is not getting represented. Because apparently the services in Kashmir, the services made in Delhi, where do I direct them to serve here?
Ministry of Law, any service, Union of India, let the services be done at 11A Strand Road. Ministry
11A
of Law.
Strand Road.
No.
Hmm.
62.
I am for that. My lord, in this 62, my lord, I am praying that, my lord, they are giving me the copy of the exception last evening, my lord.
Why?
I am
My lord,
praying, my lord, just 2 days accommodation, so can I talk to our.
6th of June.
My lord, in the meantime, we are filing our report and my lord.
All right, as per lordship, last direction, my lord, I have served the.
Exception.
Please, this takes.
The report.
All right, as per your lordship direction, I have served the copy to the added respondent. My lord, this is the affidavit service, my lord, kindly kept.
Affidavit of service filed in court today. Evidencing proof of service on the added evidencing proof of service on the added respondent is retained with the records. Full stop. The report and affidavit and exception thereto are also retained with the records. Full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on June 5, 2023 bolded. Full stop. Serve a copy.
Great.
Deeply obliged.
Yes, lordship. For the petitioner, lordship.
Line for the respondent number 3, my lord.
The other respondent. One, two, six, seven. The last day of the hearing, lordship, the direction was given upon the respondent number 1267 that one memorandum dated 11 June 2015 that upon this memorandum they wanted to clarify some partial modification or any other changes has come or no. So far the question in respect of this particular memorandum, this has been created after modification of 2 others geo numbers, that is 3804.
So where is Mr. Basu Malik?
Probably he knows that today.
Because he has to submit whether
Yes.
Memo of June 11, 2015 has any applicability
Yes,
on
Lordship.
the promotion of the petitioner,
Yes, Lordship.
on the date of the promotion of the petitioner?
The promotion has already been granted. I have been promoted from LDC to UDC in the 2008.
I'm the principal accountant general.
7.
Apart from the answering respondent, all are here. Come back on the 5th.
5th. Shall I serve the notice to other?
Yes, try to bring the answering respondent.
Yes. Great.
In 64, I'm appearing Union of India.
My lord, I am for petitioner. My lord, kindly make it not today, my lord, because my lord, my senior is code number 230.
5th of June.
5th June. My lord, only not today, one. Man.
I appear for the union. of India.
My lord, this
Application.
petition was moved, my lord, against the premature order of interzonal railway transfer. My lord, the impugned order is, my lord, page P6, page
Why have you
41.
filed the application?
Application for exception to the report.
Application for exception to the report.
To the report, yes.
What was filed?
They have filed the report.
Why have you not filed the exception? Why have you filed an application? Instead of making the exception ready and bringing it to the court, why have you filed this application? For what
Yes, well,
purpose?
application for exception to the report. That is. Now, my lord. your
I have
lordship-
already extended the time to file the exception.
Yes, I have filed that.
Yes.
Now your lordship kindly come to
1 second, let me just give me 1 minute.
now, my lord, in this case, my lord, the departmental proceeding and the criminal proceeding is pending. And my lord, he challenged the departmental proceeding and obtained stay order from the Honorable Court. And criminal proceeding has not yet been completed. That was pending. Now your lordship kindly come to annexure P1, page 20.
What is the fate, Mrs. Alam?
Lordship, the departmental proceeding has been stayed, so it's pending. It's been stayed for
quite some time.
Lordship. In fact, we had, after the Honorable Supreme Court had directed that all matters stay should not continue for more than 6 months, we had revived those. But then again, this court has stayed, so the departmental proceedings are stayed.
So what is the point in transferring?
Lordship, transferring was for administrative reasons and transferring from the decision of the board, Lordship. There are 2 ways that a transfer can be effected, Lordship.
Yes.
And here what has happened, the railway board on administrative grounds, I have annexed, Lordship, will kindly come to my
let me
report.
complete my
Anyway, one
submission.
second.
Is he under suspension?
No.
Now, my lord, I have been annexure P1. Your lordship kindly see the date of transfer, 21st June 2019, annexure P1. I have been transferred. Page 31.
Yes. From Ranchi to Kharagpur.
Yes, my lord. I have been transferred.
Yes.
Now, my lord, this order of transfer on 21st June 2019. Now, my lord, according to my lord, Railway Board circular, my lord, I am an enrolled member of the force. Your lordship kindly come to page 42, annexure P7. Item number 4.
Yes, 5 years.
Other enrolled member of the 5 years.
5 years.
So admittedly, my tenure has not yet been completed. But the order of interzonal railway transfer was passed. Lordship kindly see annexure P6 that before completion of my tenure, they passed the impugned order of interzonal railway transfer. Now, my lord, I took the point in my writ petition specifically that what is the extraordinary circumstances or grave reason for which they have been deviated from the rules and they passed the order of administrative transfer. My lord, your lordship kindly come to my 2 or 3 paragraphs, my lord. Lordship kindly come to paragraph 17 of my writ petition, page 10. Your petitioner states that it is evident from the said purported premature order of interzonal transfer dated such and such, whereby the concerned authority, while passing the purported premature order of transfer, did not at all disclose any reason as to what was the extraordinary circumstances or grave reason for which your petitioner has been compelled to go on transfer to another zonal railway before completion of his tenure for a period of 5 years. Now your lordship kindly come, my lord, another paragraph 20 and 21. But that is why your lordship passed the direction that file a report stating what is the reason of administrative interest. The 8th of RPF Act, Director General issued directive dated such and such with respect of transfer of member of the force, wherein it has been clearly mentioned in point number 5, clause D, sub clause 3, regarding interzonal transfer, with general guideline that enrolled member, your lordship kindly mark it, that enrolled member of the force who is facing any DR, vigilance inquiry, criminal case, or against whom any inquiry under any criminal law, DR, or vigilance manual is contemplated or pending will not be considered for interzonal transfer. All these things are pending before me, so should not be considered for interzonal transfer except on administrative ground by the competent authority. What is the administrative ground? They have not disclosed a single line in their report that what is the exceptional circumstances, what is the grave reason for which this order of transfer was passed against me when both the criminal proceeding and departmental proceedings are pending, and when it is a premature transfer. My lord, this matter was dealt with extensively by my lord Justice, premature order of transfer, Justice my lord BANERJI. Thereafter it was upheld by the judicial bench. I am my lord. Before that, your lordship, what is my lord? Lordship kindly come to my application for exception to the report. Only 2 paragraphs. Lordship kindly come to paragraph 7, page 5 of my application for exception to the report. Paragraph 7. Your petitioner states that it is his specific case in his said petition that when there are guidelines pertaining to the tenure of posting, a premature posting must indicate some modicum or reason, in addition to mere lip service to jargon like exigencies of service or administrative reason. When an exception to a rule is carved out, the employee is entitled to know what situation prompted the exception or why the particular employee has been singled out for the exception. But when no reason are indicated to effect a premature transfer, the report will look at the surrounding circumstances. It is evident from the said purported report filed by the respondent that nowhere in the said report was indicated any reason to what was the exigency of service or administrative interest. Then your lordship kindly come to again my another paragraph, paragraph 8. Your petitioner states that the report filed by the respondent in terms of the direction of this honorable court dated such and such, whereby the concerned authority in subparagraph I to 12 of paragraph 3 has only dealt with the power of the interregional railway transfer as conferred upon them under Railway Protection Force rules, 1987. But nowhere in the said subparagraph of paragraph 3 did not specifically mention as to what are the reason behind the back of the said purported order of premature order of interregional railway transfer. It is elementary that the exigencies of the circumstances faced by the employer or the immediate administrative requirements of the employer may prompt an exceptional transfer to be made. But a lead line or a sentence by way of explanation should always be furnished in such exceptional cases rather than paying for lip service to the grounds of exception indicated in the guideline without an attempt to satisfy such ground. Such a course of action would also be a safeguard against arbitrariness and whimsical transfer. Now, my lord, your lordship kindly see that premature order of transfer was dealt with extensively by my lord Justice Sanjeev Banerjee. Your lordship kindly go through my lord paragraph. Citation. 2016 volume 3 CLJ page 184. Srikanta Saha versus Union of India. Also, can you go through paragraph 14?
Yes.
In this case, cost was also imposed upon the respondent's authorities. Now, my lord.
Because the coordinate bench came to the finding that it was a punitive order of transfer.
My lord,
the coordinate bench came to the finding that it was a punitive order of transfer.
Yes. Sure. Court says that only one line is required. That why you have deviated? What is the exceptional circumstances?
Yes.
I am harping my lord again and again that that line was not disclosed
Yes,
anywhere.
that I have understood.
Now your lordship against that order, they prefer an appeal. My
Why
lord,
have you not given me, brought photocopies of the decisions?
my lord, certainly I shall give you.
Yes, you should have
Now-
brought them.
My lord, they prefer an appeal. My lord, this is my lord, 2016 volume 3, 2016 volume 3 CHN code 81. Paragraph 7 and 9. Well, I am reading only paragraph 7
Just give it
because
to me.
they have taken.
Give it to me. I'll just. go
Yes,
through
yes.
it.
In this case, rule 90 also, my lord, considered. Paragraph 7 and 9, your lordship kindly. Court has also considered rule 90. 7 and 9, my lord, very important paragraph.
Yes.
Now, my lord, I am referring also on the identical point, another division bench judgment of our Honorable High Court. 1982 2 CHN, page 157.
You have referred to a recent judgment, then.
No, because my lord, this judgment, my lord, why I am referring, because the court says that you have a power to transfer, but you will have to justify that what is the extraordinary circumstances.
Yes,
or
that
ground.
this judgment also holds that.
My lord, the paragraph 13 of this judgment, the judgment which I referred, lordship, what the division bench says, but if an order of transfer does not disclose any reason, either in the orders itself or in the affidavit in the opposition, such order cannot be sustained. So far as the instant case is concerned, the position of the respondent is yours for the ground that has been alleged in the affidavit in the opposition in support of the order of transfer has been found to be not true.
All right.
No ground.
Yes, anything else?
Should I? And my lord, the another judgment of the apex court also. My lord, I am giving you a lesson. Apex court judgment also. '93 supply volume 3, SCC, page 35, paragraph 16.
Volume 3.
Huh? 90. Page 35, paragraph 16. Paragraph 16.
Yes. Facts are different. Yes.
My lord, another irregularity in that order of transfer itself is there, subject to the correction of your lordship. Lordship, kindly come to rule 91.2 of the RPF rules. 91.2.
RPF Act আছে। Railway Protection Force Act আছে।
Ninety 1.2.
Yes.
All interzonal railway transfer, has your lordship got it?
Yes.
Interzonal transfer of the enrolled member of the force shall be ordered by the Chief Security Commissioner concerned after obtaining the concurrence of the Director General. So, my lord, here there are two authorities. One authority is the transferring authority, another authority is the concurring authority or approving authority. There are two authorities is there. So,
yes.
So after the order of transfer passed by the interzonal transfer order passed by the Chief Security Commissioner, after taking approval from the Director General, lordship kindly come to the impugned order of transfer. Annexure P6. Director General himself cannot directly transfer me. He is the concurring authority. The order of transfer must be passed by the Chief Security Commissioner. Lordship, kindly see the order, input order, page 41. In terms of railway boards, letter number such and such, that is the order of the Director General. Data such and such, the following RPF personnel of Southeastern Railway have been transferred to other zones on administrative ground as mentioned against them. Now, your lordship, kindly, these four writ petitioners are before your lordship. Now, lordship, kindly come. This is issued, lordship, kindly, this is issued with the approval of the IG Principal Chief Security Commissioner. What is this? IGCOM Chief Security Commissioner is not the approving authority, he is the transferring authority. Approving authority is the Director General. Director General will approve. The order which would be passed by the Chief Security Commissioner would be approved by the Director General. Chief Security Commissioner being a transferring authority cannot be the approving authority. Yes. Now, my lord, my submission before your lordship, when the Chief Security Commissioner has entrusted with the power of intergeneral transfer, the Director General cannot, being a approving authority, cannot pass the transfer order directly. He will give the only approval. On this point, my lord, the division bench of our honorable High Court also, my lord, consider this point 91 point. Considered. I am referring the judgment, my lord. 2007, volume 2, CLJ, page 694.
Mr. Mojumdar, I have one question.
My lord.
I have one question.
My lord.
At page 31 also there is a transfer order.
Page 31.
Yes.
Yes,
you-
yes.
That one you accepted.
Yes, because within the zone. That is one place to another place within the zone. I have accepted that. But it is far away place.
You
From one zone
accepted
to another zone.
even though it was not in conformity with 91.2.
91.2 is not applicable here.
Why?
Because it is a transfer within the same zonal railway. But 91.2 deals with interzonal railway transfer. You'll also kindly come to page 31.
Yes.
I have been transferred from one division to another division within the same railway.
Then if that be so, then I have to see when were you transferred to Ranchi division? Because today you are asking me to compute the tenure of service from June 21, 2019. Then if your argument is that that is between the same zone, then I have to see when were you transferred to Ranchi division? Why will the computation not be from that date? And why will it be from the date you got transferred to Kharagpur division?
Yes. Last kindly again come to the Directive 32. Directive 32. Page 42.
Yes.
I definition transfer. IA. Railway Protection Force. Any regular posting from one RPF post, outpost, company, unit of office to another RPF post, outpost, company, unit of office in the same division or in another division or in the same general railway. So this is the regular posting. According to 1A, from Ranchi to I have been given posting to Kharagpur. This is my regular posting. And then you logically come to premature, definition of premature transfer. Definition premature transfer. That is 919. Premature transfer before completion of tenure as prescribed. So I have got the regular posting in terms of 1A from Ranchi division to Kharagpur division. This is my regular posting.
All right. Yes.
And my lord, I have given the reference.
All right,
2007.
you have finished? You have completed?
Yes, paragraph 9, my lord.
Yes. Yes, Mrs. Alam.
Lordship, I would take some time to get myself ready with my learned friend.
So I am now extending the interim order.
Lordship, let that be. And Lordship fix it.
Mr. Mojumdar, learned counsel appearing on behalf of the petitioner, submits that in case of a premature transfer, the reason for administrative exigency should have been revealed by the authorities in the order of transfer. Full stop. He relies on a coordinate bench's judgment reported in 2016 within bracket 3 bracket to CLJ 184. Eta pore neben ekhan theke cost title ta bold and also full stop. The said order of the coordinate bench has been affirmed by the Honorable Division Bench. Full stop. He refers to the Division Bench's judgment reported in 2016 within bracket 3 CHN 481. Eta bracket er moddhe cost title ta pore debe bold. Next. Mrs. Alam appears, learned counsel appears for the Union of India. Full stop. Let the matter appear for further consideration on June 20, 2023. Full stop. The interim order passed earlier will be extended till July 31, 2023. Full stop. Let the matter appear to bolei diyechi on June 20 under the same heading motion. Ogulo bold e kore debo.
My lord, rest 3 matters are analogous matter, involve same point. 66, 67, 68.
Same order kore debe. Can na eta exception uni can korechen. Eta to dispose korte parbo na ami. Eta to he has, this is an exception to the report. So he has filed a can for what reason I don't know.
Item 67, I have something to say.
Lordship,
একটা একটা করে ডাকো নালে appearance গুলো হবে please wait, I'll call one after the other so that the appearances can be recorded.
Lordship, I appear. Lordship,
Same, identical matter. Same point are involved.
Lordship.
Same point are involved. Identical.
You are
matter.
appearing, Mr. Bhattacharya.
I'm appearing for
Yes, please.
No, I'm filing every.
Report on affidavit. Report on affidavit filed in court today is retained with the records. You have served your learned friend.
Yes.
And I filed application for exception.
Why did you file? You just have to file the exception. Why have you filed this application?
আমাকে দিয়েছেন কপি? No. I mean, my lord, I have something to say. This is not premature transfer.
All right.
The petitioner,
I will hear all the matters together. Their analogous point, I'll hear all of it.
my lord, then in this matter also, let there be an order. Your lordship.
Yes, these orders are passed in all the matters.
Oh.
Separate orders. I'm just calling one after the other so that your appearances can be recorded.
68. He has already.
67.
Well, the petitioner has already joined the post, transferred post. So I don't know whether.
No, I have not joined the task
I
force.
kept the order in abeyance.
Rachi, that is not my condition.
But he has joined as instructed.
He is working in Ranchi. I have kept this order in abeyance.
No, he has joined in the meantime. What my learned friends say. Yes, because
He is working in
I have been
Ranchi.
transferred to another zonal railway, Southwestern Railway. I have not
From
joined Southwestern
Kharagpur to
Railway.
Ranchi, he has been transferred. He is working in Ranchi from 2019.
Yes.
Now he has been transferred in a different zone.
সে তো রাঁচিতে করছে not properly instructed. No, not properly. He is instructing. Properly instruction. Why you say? তো তাহলে ওটা জেনে বলুন নেক্সট দিন যেদিন আছে সেদিন জ্বালা এই বইগুলো থাকবে ঠিক আছে ঠিক আছে এটা আমার এটা ওই আমি ভুল দিয়েছি ওইটা না
69 Lordship, in this matter, I am appealing for the petitioner Lordship. In this matter, Lordship, the petitioner Lordship was retired from his post as a Group D staff. As Group D staff Lordship, he was retired from service. Thereafter, his PPU was issued Lordship, but at the time of disbursement, some amount was deducted. Challenging that Lordship, the petitioner came before the Honorable High Court. Your Lordship initially directed to file report. Lordship, report has
What
been.
do they say in the report?
Yes. Report has been filed, Lordship. I have also filed my.
Yes, what do they say in the report?
They have said, Lordship, that they have deducted on because, Lordship, some overrun was there during the service. Some pay was fixed by the concerned employer, Lordship, erroneously. Now, Lordship, similar type of issue, Lordship, was came up before this Honorable High Court, and I, Lordship, annexed the order of the coordinate bench, Lordship. When, Lordship, this Honorable High Court earlier in discussion with the Supreme Court or judgment and Lordship that after retirement, no overdrawn can be Lordship deducted.
Yes.
And
Where is Miss Sinha? I have also passed orders.
yes, Your Lordship.
She is the answering respondent.
Right. Yes, Lordship. See, last occasion she filed the report, Lordship, but today we could not see. Very small matter, Lordship, petition. চলছে Lordship, I have been informed by his clerk, Lordship, that she could not come to court, Lordship, just due to illness, Lordship. Because of her illness, Lordship, he could not come. She could not come to court, Lordship.
Personal difficulty, 5th of June.
70 Lordship, same matter, Lordship.
I am for the petitioner. My learned student Mr. Godhakurata is like in another court. I am praying for short passover.
5th of June.
5th of June. 22. I am for the petitioner, my lord.
My lord, I am appearing for the
My
private
senior are
respondent.
going to be court online. my lord.
I am from vehicle. Yes, my lord, I am appearing.
Yes. My lord,
My lord, that.
On the last occasion, notice was to be served on Kolkata Port Trust, my lord.
Yes.
I sharp my lord.
You have served.
My lord. No copy, my lord.
Affidavit of service?
My senior.
Your senior is there.
Yes,
Your senior will
My lord, what?
be affirmed.
My lord, what happened by the way? Principally said his guide because I am thinking suddenly no matter appear in the Supreme Court, I had to transfer and file is lying with me, my lord. That is the problem. Kindly day after tomorrow.
You do something, you serve on Mrs. Mukherjee, who usually appears for Kolkata Port Trust. Ashwin. Despite service, no one represents the Kolkata Port Trust. Full stop. This court directs a copy of the writ petition to be served upon Mrs. Mukherjee who usually appears for the Kolkata Port Trust. Full stop. A proof of service is to be filed on the adjourned date of hearing. Full stop. Let the matter appear for further consideration under the same heading motion, bolded, on June 20, 2023, bolded. 20.
Just one prayer, just one prayer. Just one prayer. He is not getting one paisa from the compromise. He's starving. So, my lord, I sought that because court deliberately because my lord directed this chairman to file an affidavit instead of the one.
Let them come. Without their presence, I cannot do anything. Let them come.
But allocation, my lord, you are directed to file affidavit within 7 or 10 days, but after 2 months they have filed the affidavit, and that has also been not submitted before the court. It is a pension matter. He's starving actually. That's why I'm praying that the
You come back. All right, come back. Let them come back.
That is well because. But one after petition is filing against him for maintenance, and he is not getting any one paisa from it. And already warrant of arrest also is filed against him for not payment. But that is there.
No, I beg to appear on behalf of the petitioner.
For the respondent, my lord, state fishery, my lord.
And I am opposing this prayer.
My lord,
I am opposing this prayer.
my lord, learned advocate, my lord, Shanti Das, my lord, did not come to the court, my lord, for personal difficulties, my lord. Kindly, my lord.
I am opposing this prayer. I am opposing this prayer because on last occasion, it was adjourned on the because she was not well. But I do not want to disclose, but
Come back on the 5th.
This matter relates
I'll
to
record an order.
this matter relates to that they have admitted in the report that the payment is due.
What the state respondents in this matter, my lord?
Yes, you have nothing to do.
The payment is due. They have admitted in the report that report is already on your
Mr.
record.
Maiti, comma,
Shanti Das.
learned counsel appears on behalf of the petitioners. Full stop. Ms. Das, comma, learned counsel appearing on behalf of the state
conference
fisheries department.
submission করছো
State Fisheries Development Corporation
আসতে পারছেন না সেটা বলতে পারো কোর্টে আসেনি সেটা বলছো কেন
is not present in court today. Stop. An accommodation is sought for on her personal grounds. Full stop. Next, Mr. Maiti opposes this prayer on the ground that such adjournments have been taken on previous occasions. Full stop. He submits that the claim of the petitioners have been admitted in the report on affidavit filed on behalf of the State Fisheries Development Corporation Limited. Next, in the interest of justice, since personal difficulty of the learned counsel has appearing on behalf of the answering respondents have been submitted, this court adjourns the matter. Full stop. Let the matter appear for further hearing on June 5, 2023, bolded, when it is expected that the answering respondents will be represented. Full stop. Server copy.
And I have a conference with her at 3:30 after court in the court premises.
Once you hold the conference, please notify this court that she has been present for that on the next date of hearing.
And
I'm
this,
going to
this
remember
is not expected. If someone is in court, they will submit that she has not come to court. If she does not come to court, I consent that it's okay. If she comes to court and submission is made that
It's absolutely not acceptable by this court also. But if you see her in court today, please inform this court on the next date of hearing. Because that is the reason I have recorded the entire thing. Now you submit that before the court.
My lord.
74 to appear for the petitioner.
My lord, in this matter, Mrs. Dr. Chakraborty is appearing on behalf of the answering respondent. For her mother-in-law is very
Again, personal
seriously,
difficulty.
seriously ill. He has went for the Fortis hospital today itself on the appointment. He is suffering for cancer. Last stage.
Personal.
I know.
5th of June.
My lord,
5th of June.
5th of June. Deep level.
I'm grateful.
Last occasion, Lordship, direction to file a
You
report.
are for repeat the petitioner.
Yes, my lord.
Kindly come
Yes,
this side.
Sorry. Last occasion, your lordship was pleased to direct the learned advocate appearing for this case to file a report. Thereafter, on 2nd May, again matter was came up for consideration before lordship, and lordship again directed to serve notice that the matter will appear.
Stated हुए क्यों appear करते हैं?
But till date, no report has been filed, my lord. Past order of passed on 20th December 2022, thereafter 2nd May 2022. I have served notice by intimating.
1 minute. Do you know Mr. Nag?
No.
Have you informed him personally? So what happened? Why is he not coming? What has he said?
So why?
Have you spoken to him? I can't hear you. Have you spoken to him? You appeared on the last occasion.
Yes, Lordship. I have served the notice, Lordship, and his clerk was received the notice.
And she stated to his clerk, informed his clerk that matter will appear in next day. That is. No report has been filed.
No report has been filed.
No. Till now.
Ashwin, the last chance. As a last chance to the state respondents for filing of the report. The date is extended till June 9, 2023, full stop. Exception, if any, by June 16, 2023, full stop. Next, let the matter appear for further consideration under the same heading motion whole day on June 20, 2023, full stop. Next. On the previous occasion, when the matter came up for hearing, the state was not represented, full stop. The state is also not represented today, full stop. This court had requested. The state is also not represented today. This court had directed a further notice to be served upon the learned advocate representing the state, full stop. It is submitted by Ms. Hussain, learned advocate appearing on behalf of the petitioner, that the learned advocate for the state respondents have been served, has been served pursuant to the directions of the court, full stop. Despite such service, the state is neither represented today, nor any accommodation is paid for, full stop. Next. Such a conduct is not appreciated by this court, full stop. However, in the interest of justice, this court gives another opportunity to the learned advocate appearing for the state respondents to make his submissions on the adjourned date of hearing, full stop. It is expected that the state will be represented on the adjourned date of hearing, full stop. Next. ওগুলো তো হয়ে গেছে যে ওগুলো তো হয়ে গেছে ডেট
Matter will appear on
20th
June.
In the meantime, if they file the report the court will be accepting that. Otherwise-
I shall communicate to your lordship so that tomorrow or day after tomorrow, I shall communicate. Grateful.
No, for the Union of India. madam.
I'm for the
Kindly come this side.
I'm for the petitioner, my lord.
Yes.
I appeal for respond number 2 to 5, your lordship.
My lord, I'm led by Mr. Shabushi Chatterjee, my lord. He is against court number 13. I'm praying for not to my lord.
5th
Lordship.
of June.
Lordship, in this matter, on the previous occasion, your lordship had directed us to file our additional report to the supplementary affidavit. Your lordship, the additional report is ready, but it has gone for signature to the CEO.
Yes, I'm just keeping it on 5th of June.
Lordship. In the meantime, I'll file my additional.
Yes, yes, I'm just.
Obliged.
Yes.
77 I for the respondent.
My lord, 77, my lord, I am for the petitioner, my lord.
Yes.
Kindly, my lord, after vacation, my lord, learned advocate Gaji Farooq Hussain, my lord, he very ill, my lord.
20th of June.
May I permit to submit my affidavit in opposition in court? Kindly consider.
Ashu. Report on affidavit.
Affidavit in opposition, my lord.
Are you appearing for the private respondent?
No, my lord, on behalf of the respondents.
Did I direct affidavit in opposition or
Yes, it is
report
direction
on
was-
affidavit?
But direction was given, my lord.
Report হবে তাহলে opposition হলে তো hearing is over. Report on affidavit, Ashu. Report on affidavit filed on behalf of the respondents is retained with the records. Full stop. An accommodation is paid for on behalf of the petitioners. Full stop. Next, let the matter appear for further consideration under the same heading motion, bolded, on June 20, 2023, bolded. Serve a copy.
Grateful.
My lord, 78 and 79 are analogous matters. I am appearing for the petitioners.
My lord, in this matter, my lord, I'm appearing for respondent number 4 and 5, my lord. My affidavit is, my lord, not prepared, my lord. My lord, all documents have been supplied with on belated period, my lord. My lord, standard my lord.
23rd of March, your lordship
my
has
lord.
passed the order.
23rd of my
Last
lord.
occasion, he has not appeared.
Yes, my lord. That's absolutely true, my lord. I'm not denying anything, my lord. But my lord, I have the instruction which is required to deal with the matter, my lord. Sufficient instruction was
It
not
appeared,
provided.
when did it appear previously?
23rd of March appeared. Thereafter, my lord, 2nd of May appeared.
It was called on when they were.
Yes, my lord, you have called on.
Yes. Absolutely correct, my lord. I'm not denying, my lord. My lord, the last opportunity we given, my lord, to file, my lord, affidavit, my lord, this is very much relevant. Because the commission says that I supposed to pay the implementation of ROPA on and from 1st January 2022.
Yes.
And accordingly, I communicated to the PWD principal secretary that my financial condition is not as per this. I am not paying regular basis the remuneration of my continuing labor. How could I pay, my lord? To that effect, my lord, my communication is there. My lord, to the principal secretary who passed this order for implementation. My lord, this document, my lord, I want to bring on the record. True, my lord, this report.
So what were you doing from March? This
But,
communication.
it's a
you
government
should bring on
company, my
record
lord.
From March.
My lord, that's true, my lord. I made several communications, my lord, asking for this, and even your lordship was just today. Before the matter is taken up, my lord, I received a mail, my lord. With this document, my lord, this document is lying with me, my lord. I've taken one, my lord, print out copy, your lordship can seize it. My lord, I want to bring this on record, my lord.
Yes, so what were you doing? For 2 months?
My lord, for my lord, the period was there for up to my lord, 21st of April, and within that time, my lord, it's not filed. For last opportunity, my lord, opportunity given, my lord.
16, 2023, full stop. Exception, if any, by June 23, 2023, full stop. Let the matter appear for further consideration under the same heading motion on July 3, 2023. Motion on July. Serve a copy.
My lord, may I seek one indulgence, my lord? Since, my lord, the state respondent is also appearing, my lord, let them, my lord, file their affidavit also.
I have said a report. Whosoever wants to file, I have not directed you to file.
My lord.
Please look at the order.
My lord, my lord. My lord,
I
order
have
is on
asked
me
the parties to file a report. Whoever wants to file will.
because my standpoint depending on them, my lord. Right now, my lord,
First, you bring your stand on
my
record.
lord, grateful, my lord,
Let them.
grateful.
79 million, the same.
Same.
Analogous.
Analogous, my lord.
Same order.
Grateful.
I'm great.
I am for the petitioner. This is the ROPA 2019 benefit. To, my lord, the only theme.
Where is Mr. Mukherjee? Where is Mr. Mukherjee?
Engaged, question number 11.
Only 4 employees are left.
Yes.
And Mr. Mukherjee wanted to take necessary instructions on the last occasion. That is in March.
And DCL, my lord, the sent proposal, my lord, the for disbursement of for grant of benefit. Already, my lord, the Durgapur Chemical Limited sent proposal. That is
Yes,
the.
Mr. They submitted that on the last occasion.
Yes. And as per the
Next to only 4 employees, I had asked Mr. Mukherjee to take instructions.
6th February also, my lord, they did not choose not to appear. Again, my lord, the losses.
Ashwin. Mr. Mukherjee, learned additional government leader, was directed to take necessary instructions regarding the issue as to how and when the benefits of ROPA 2019 may be given to the petitioner. Full stop. The petitioner is one of the remaining 4 employees of Durgapur Chemicals Limited within bracket DCL bracket closed, who have not received the benefits under ROPA 2019. Full stop. Next. The state is not represented today. Full stop. Next. In the interest of justice, let the matter be posted for further consideration under the same heading motion on June 5, 2023.
It is my lord, the before vacation, if it's possible. 5, 6, 7, I will be out of station.
On June
8 or 9.
12, 2023.
Well.
Serve a copy.
And also, my lord, after the last order, I have given a notice to Mr. Mukherjee and his junior.
Mr.
Even then, my
Mukherjee
lord,
appears in the matters he wants to appear. Where is his junior? Now she has also gone.
Yes. Somnath Noskar. Somnath Noskar.
81, same order. You are appearing in 81.
I'm for the petitioner.
My lordship, I am for the respondent. My lordship, in this matter, Mr. Pushpal Chakraborty is appearing. He is out of station. My lordship, if my lordship permits, then my learned senior may submit his submission. I will take down the note. On the next occasion, we will submit.
Yes.
My lord, I'll do that. Lord, may I file my exception to the report? I have already served a copy upon that. My lord, this pertains to that Central Coalfields matter. Lord, whereby the there is a wrong pay fixation on account of the petitioner, my lord, was retired way back in 2012. And her benefits was primarily being deprived on the account of VDA. There is a distinction which has been sought for on account of 26 days VDA and 30 days VDA, my lord. So your last occasion, your lordship was pleased to pass an order directing them to deal with a specific query, my lord, that forms part of the page 3 of the order, starting from page 2. Mr. Chakraborty, having considered the rival submission, my lord, I'm relying upon the last paragraph of page 2 of the last order. This court feels that justice will be served up by directing the respondent number 3, Director Personnel CCL, to file a report on affidavit explaining how the conclusion that the petitioner was initially appointed at Semra Colliery was arrived after taking into consideration clause 5 and 9 of the appointment letter. Dated, I have relied upon the appointment letter which has been issued by Central Coalfields at that point of time, 25th of January 1974. Lord, kindly, if we now look at the exception affidavit which has been filed by them, my lord.
Yes.
National NCWA 1 came in the year 1973, my lord. The appointment of the petitioner was done in the year 1974, that is 25th of January 1974.
Yes.
Lord, so the question of your petitioner being a taken over staff, because in 1973, at the time of nationalization of the coalfields, they have rightly pointed out the alleged coalfield from where they have taken a stand that I am a taken over staff from a Semra Colliery, which happens to be a private colliery at that point of time. By virtue of nationalization in 73, Semra Colliery was taken by the government. Now, thereafter, in 74, I was being appointed. So the question of I being a taken over staff in the year 1974 cannot arise. This is my first point, my lord. The second is, petitioner is assailed. My lord, they have also taken a point that I have not assailed about my wrong pay fixation within a proper time. My lord, in my exception to the report, I've relied upon a document. For the first time, I have assailed this wrong pay fixation in the year 84, my lord. 25th of June 1984. If your lordship be pleased to come, lord, page 8 of my exception to the report. Lord, if I'm allowed to place, my lord, respectfully, the subject matter is anomaly of fixation. Respectfully, I beg to state that I was promoted to the post of UDC on 30th of September 1983, and my pay was fixed at rupees 982 with effect from same date in the pay scale of 672 to 1422. Subsequently, on 13th of April 84, a promotion order was issued by the administration promoting my juniors to the post of UDC, and the pay having been fixed at appropriate stage with the office order number such and such, dated 20th of June 1984. On perusal of the said order, it has been observed that the pay of...
It's a clear case of anomaly. You have said that.
It's a clear case of anomaly, my lord. 84, I have stated. My lord, apart from this also, my pay fixation not only affected at the initial point of time when NCWA 1 was implemented, and it went on continuing because of the cumulative effect which has not been given to me way back in 1974, my lord. Look, that was my case. Even after I have given a detail of the pay fixation, what ought to have I should be entitled to receive if my pay fixation has been done in a proper manner, my lord. If I am allowed to rely on, my lord, page, starting from page, my lord, '51 onwards, my lord, 50 onwards. My lord, this has been prepared at my behest. On the very first column, my lord, 25th of January,
Where are
19.
you reading from?
My lord, page 50 of my exception to the report, my lord. This is a statement prepared at my behest, reflecting the pay fixation which I am ought to have been received. My lord, 25th of January, my pay was fixed at rupees 205. And by virtue of yearly increment, I am entitled for 212 in the year 1975. 25th of January 1975, my first increment was supposed to be implemented at that point of time. In the meantime, my lord, NCWA 1 came into picture. Thereafter, I was entitled to 378. But if you see the pay fixation, my lord, as per NCWA 1, whoever was entitled for 205 at that point of time, the fixation was revised to 378 by virtue of implementation of NCWA 1. But that does not curb the right of my increment, which I'm entitled since 1974. I have already worked for a year. I was entitled for an increment, but that increment was not given at that point of time. If that increment would have given, my lord, at that point of time, then I would have been entitled for 396. Now, this anomaly continued till end of my service.
That is the problem. You have woken up after so long.
I bow down.
That is the main problem. You have retired from your services in 2012 and now you have suddenly woken up from your slumber.
Well, I have assailed this thing. Look,
in 1984.
1984, my lord.
And then
my lord,
you retired from service in 2012.
2012.
And now we are in
2023, my lord. Before that,
And when
also
did
in
you file the
2005 for the first time, my lord. For the first time in 2005, I have assailed this thing before the Red Court, before this honorable court. They have, but they have rejected my plea, or the court have decided saying that the distinction cannot be sought to be drawn on the distinction of VDA, variable day earnings allowance, because they have tried to draw on a distinction saying that since I am a taken over staff, I was entitled for 26 VDA. So that point has been taken by them similarly once again in this round of litigation also. Well, I bow down before your lordship saying that I am late before this court, coming late before this court, my lord. Well, that is my only discrepancy what I have.
anything else?
My lord, one more thing, my lord, if your lordship can come to my lord, page 22, my lord.
23 of
I'm sorry, my lord, page 49, 48, my lord, 40 of my exception to the report, my lord. 48, my lord. 48, my lord, 48, my lord, serial number 9, my lord. This is the promotional order. If your lordship kindly see, serial number 9, Shobita Mojumdar, Shobita De, my lord, Shobita Das, my lord. Legal, the date of joining is over here, 83. The earlier pay was 692. Now it was been revised. I have been treated under the grade of 572. Now it has revised to 748. My lord, this is dated 14th of November 1983, my lord. My lord, page 49A is the pay advice slip of the petitioner, my lord. 49 is the type copy, 49 is the original pay advice slip, my lord. This is for the month of October 1983. Now, kindly see the basic pay. The basic pay in October 83 was 715. Now, my lord, if you compare it to page number 48 at the promotional order, it will be evident, my lord, I've been treated under the scale of 692 instead of 750. So the anomaly not only happened way back in the at the time of first implementation of the NCWA 1, my lord. It went on continuing, and time to time it has been decreased.
They are saying that you are not entitled to it. One, because you have been a taken over staff. And even if you are able to satisfy that you are not a taken over staff, the thing is that you are approaching this court way after you have been superannuated from service. These are the 2 points primarily they are taking. They are not disputing that if it was implemented during that time, what they are not addressing that on merits.
But I appreciate, very well appreciate. My lord, in that event, for the point of delay and limitation, kindly allow me to submit on the next day, my lord. I'll try to satisfy your lordship.
After the learned counsel appearing on behalf of the petitioner submits that the petitioner has not agitated the grievance relating to anomaly in pay fixation after her retirement, but long before, in 1984. Full stop. He relies on a document dated June 25, 1984, annexed to the exception in support of such contention. Full stop. Which page of the report did you point to?
My lord, there is page number 8 of the exception to the report, my lord.
No, that is different.
Lord.
For showing your appointment as an employee of Coal India, which page did you refer?
My lord, that is page 31 of my petition, my lord.
Also refers to the letter of appointment dated January 25, 1974, to show that the petitioner was appointed by the Coal Mines Authority Limited and was not appointed at Semra Colliery stroke private colliery. Full stop. He also submits that from the report on affidavit, it appears that the respondents have admitted that the petitioner was appointed on January 25, 1974. Full stop. Next. An accommodation is paid for on behalf of Mr. Chakraborty, appearing on behalf of the respondents. Full stop. Next, let the matter appear for further consideration under the same heading, motion on June 20, 2023. Hold. আর এটা কি ফাইল করেছে আজকে? কি দিল আজকে? কি ফাইল করলো না রিপোর্টটা না? You filed your exception
I
today.
filed my exception. to the-
প্রথমে exception as handed over in court today be retained with the reports. So they're admitting that you have been appointed in 74.
Well,
That
technically
much-
they are admitting, but
But they're not saying, they're saying that no increment was given to you before NCWA 1.
my lord.
All right.
Well, I understand the difficulties in absence of one of the advocate representing the respondent, right?
My lord, the
Let-
advocate for the respondent is not keeping well, and she is not keeping well for a long period of time. So, my lords, humbly pray if the matter can be adjourned after the vacation.
That matter, last matter also, she was representing that every day the matter is being adjourned on the month of January. You passed an order directing them to file report.
Shanti Das.
We are not receiving salary, and they have admitted this fact in their report. All that I'm praying today, Mlad.
Today, Mr. Maiti will see whether she is there in court today.
Yes, she is there. She is there in court.
Mr. Maiti will come and report on the adjourned date of hearing. That.
She is there, Mlad. The difficult
Why
matter
have I kept the other matter?
on 5th, Mlad, may I pray this, Mlad? Let them release the salary for the current month so that I can survive.
Let her come. Let her come.
But every day, every single day, I'm receiving phone from my client that we are not in a position to survive. That's the whole difficulty. That's the reason why every single time they receive 5,000 per month.
Court and she is submitting that she is not well. I cannot understand.
Everybody is calling me that I can't say anything. But this is the difficulty. My client, they receive hardly 5,000 per month. If they do not receive this money, how will they survive?
All right, next. I'll pass an order whether she is here, not here.
Grateful, man.
My lord, I am for the petition. My lord, may I submit?
This matter, my lord, your lordship kindly sees matter order dated 23rd of February 2023. This matter, your lordship has already passed an order, my lord. But after passing an order, my lord, your lordship wanted me to take instruction relating annexure, my lord. Kindly see that order, my lord, first, my lord. 23rd of February 2023, my lord. My lord, this is the instruction which I have received, my lord. My lord, this what happened, my lord, in this matter, my lord, this petitioner, my lord, he was not attending, my lord, the service, my lord, from 2008, my lord. From
was not
2008,
attending?
he is not attending the service, my lord. He is not attending the duty. Now, thereafter, my lord, in 2010, my lord, we have dismissed it by way of a disciplinary proceeding, my lord. That all documents, my lord, we have submitted before your lordship and under instruction, my lord. Now, thereafter, my lord, in 2013, my lord, he has made a mercy petition before us, my lord. In mercy petition, my lord.
In 2013?
2013, my lord. Mercy petition was made, my lord. Kindly, my lord, come to my lord. Application, my lord, in Hindi, my lord. That page 3, my lord. That is the mercy petition. And now, my lord, thereafter, my lord, kindly see the instruction which the ECL has given us, my lord. That next last page, my lord. As per clause 30, certified standing order applicable in ECL, the employee should, that is given, that within 45 days from the date of that order, he should file an appeal. Here, he has not filed an appeal. The ex-employee, Lalan Harijan's father of the petitioner, applied for a mercy petition, which was forwarded to the competent authority. Accordingly, he was called for by the general manager PNIR ECL on 10th of September 2013. Communication filed later at such and such minute, along with 10 other employees. But the competent did not accept the mercy petition of any of the employee mentioned in this letter. So, my lord, the point, my lord, which he was to want to make, my lord, that his father was not known about this termination. Firstly, my lord, his petition starts from 2012, whereas, my lord, we have terminated with 2010, my lord. Now thereafter, my lord, it's also clearly shows, my lord, his father knew that he has been terminated, and my lord, his mercy petition was rejected. His father chose not to challenge that. He kept mum, my lord. Thereafter, his father died. Thereafter, after 1.5 years, my lord, the petitioner came before your lordship, challenging the same, my lord. So, my lord, your lordship had dismissed this matter, my lord, and order is kept in abeyance, my lord. I'll pray before your lordship to keep that same order, my lord.
So now the Coal India has given all these things to you. Where is the order of dismissal?
My dismissal, my lord, I have handed over to your lordship an instruction, my lord. In that instruction, my
So
lord.
I am looking at those two orders. One is of August 2028 and one is of August 21, 2013.
28, 2013.
August
Your lordship will
26,
find the
2013.
termination order in this bunch, my lord. Otherwise, I am again submitting, my lord. My lord, that day, my lord, I had
That is page number.
my written instruction, my lord, page 26, my lord. I written it down, my lord. I have given you a bunch, my lord. My lord, this is dated 15th of March 2010, my lord. My lord, termination of service, my lord. Before that, my lord, I have handed over, my lord, 5 notice was given to him for inquiry, my lord, which he has not come. He has turned off. Charge sheet has been found, also been made, my lord. Every proceeding, my lord, I have given, my lord, from the beginning, my lord. Now the last, my lord, is my lord 15/3/2010 when he was terminated, my lord. Kindly see, my lord, this is with reference to the charge sheet number such and such issued to you to you for your remaining absent without information or permission from the competent authority since 22 October 2008. Since
Just 1 minute. Yes, I have recorded about this
everything.
here.
Yes, ma'am.
Now, what I am asking you is something different.
Okay,
You are saying that you have rejected his mercy petition.
my lord.
That is your instruction in 2023. That you have rejected his mercy petition on 16th of August.
But your lordship direct me, my lord, that but this mercy petition was rejected, my lord, on that date only, my lord, way back, my lord, on 10/9/2013, my lord, it was rejected, my lord.
Yes.
This, my lord, they are I wanted a written instruction from them, my lord. That's why this mail has been given to me. Well,
Please try to understand my difficulty. You have given me this mail of 2023. You have also supplied 2 documents.
yes, my lord.
Document number 1 and 2.
Yes, my lord.
These are also dated 2013.
2013, yes, my lord.
Yes, both the documents are dated 2013.
Yes, my lord.
In both the documents, you are saying that he is called for a personal hearing with his family members.
Yes, my lord.
This is your stand in both the documents.
Yes, ma'am.
And in the first document, you have said that the hearing is adjourned till September 2013.
My lord, the first document, my lord, kindly sees, my lord.
You please see the first document, last line, last paragraph.
Last paragraph. But as such, you are required to kindly inform the concerned that an appeal before the GM prior on 10/9/2013 instead of 6/9/2013. But first document, kindly see, my lord, it was, my lord, first we have called him, my lord, on 6/9/2013. That was adjourned, my lord, and he was called, my lord, on 10/9/2013. 10/9/2013. The first document says that, my lord.
Yes.
Kindly see, my lord.
Yes. Now you please try to understand. Both the documents are of August. You do not give me any document of September, and then you say that he has been terminated. His mercy petition has been rejected. From where do I get that? Because he has been called for a personal hearing, and then what happens?
I understand that, my lord. I also asked the department, my lord, to give me that order, my lord, that his mercy
What
petition.
should I do with these orders of August
kindly see, my
when
lord.
the personal hearing has been adjourned?
My lord, mercy
What
petition.
will I see, Mr. Arifin?
Not kindly see the last paragraph, my lord, but first document, my lord. 1 second, my lord. I be mistaken, my lord. In such, you are requested to kindly inform the concern that the state ex-employee to appear before the GM PNIR on 10/9/2013 at 10:30 PM instead of 6/9/2013 at 10 PM in the office of GM Empire PNIR HQ Sartoria, and accordingly depute an officer to attend the above hearing along with all other relevant documents. My lord, your lordship lastly asked me, my lord, to take instruction relating to the second document, my lord. This one. It was this document, my lord.
Now you have to show me, because this is quite open-ended. What has happened in the hearing, you have to tell me.
That, my lord, it has been given, my lord, in this mail, my lord.
Produce a document that is open-ended, then what happens?
My lord, his mercy petition was rejected, my lord.
Yes, now you have to show me when, how. Because you've called him for a personal hearing and you do not produce that order before me.
But that document is missing, my lord. I have
That
asked him.
document is missing. Then how will I rely on your stand?
Not kindly
Then
see
you,
his application.
then you bring this document of 2023.
My lord, kindly see his application, my lord. From this application also, your lordship can understand, my lord, what he has paid for, my lord.
I can understand what he has paid for. You have said that his mercy petition is rejected. You have to show me that it has been rejected. You are showing me documents where he is called for personal hearing with his family members for hearing of the mercy petition.
Yes.
Then you come with in 2023 and you say that his mercy petition is rejected. On the basis of what?
That order your lordship wants, my lord, that your lord, I asked them, my lord, but they could not trace out that particular order, my lord.
Then how will I go by what you're saying?
But my lord, kindly see, my lord, for the purpose of this writ petition, my lord, this writ petition, this employee has not filed, my lord. The writ petition his son has filed, my lord. And his son's stand was that his father did not knew, or he was not said that what happened with his salary service, my lord. For that, my lord, I have handed over to your lordship.
I'm giving you time. You find out better particulars.
Then make a specific prayer, my lord, that order for rejecting the mercy petition has to be produced before your lordship. I understand, my lord. That's the difficult one.
Mr. Arifin produces written instructions before this court today. Such written instructions are retained with the records. Full stop. From a communication dated March 4, 2023, it appears that the petitioner's father's mercy petition was rejected by the Eastern Coalfields Limited within bracket ECL. Vide
the same on that same date.
Order dated September 10, 2013. However, the said order of rejection has not been produced before this court. This court directs such order to be produced on the adjourned date of hearing. Full stop. Next. Let the matter come up for further consideration on June 20, 2023, bold, under the same heading motion. Bold. মানে এই অর্ডারটা আমি এখন পাস করিনি, কিন্তু এই অর্ডারটাই পাস করবো, তাহলে ফ্রেশ করে ছাপিয়ে রেখে দেবেন। All right.
My lord, can it in the form of affidavit with a copy to us?
I have dismissed your writ petition. I dismissed your writ petition.
My lord,
Still, I am giving.
My lord is so annoyed. Although I have a very good case and most pathetic case, my lord. Well, my lord deserved to be, it is a fit case for consideration. My lord, if your lordship party, if your lordship.
There is a loophole, please don't try to take advantage of that. There is a loophole
my
on
lord
the
is,
respondent authority.
My lord is remaining mum over.
After notice has been given to your father, he did not appear in front of the disciplinary authority. Then, without challenging the order of the disciplinary authority, he passed away. Now you are coming. Of course, your case is not a good one. Still, because of the loophole, this opportunity is being given.
No, my lord, they are for manufacturing documents and everything, my lord. But my lord is remaining now about retirement benefits. One
I
order
could
may
manufacture not, I could have shown that order today itself, my lord. Please, I'll try, my
Then
lord.
it was disputed question of fact. Then again, the writ petition has to be dismissed.
No, no.
If this is
No,
a
I'll
question,
try, my
if
lord,
he
I'll
says manufacturing documents on his own.
No, no, I say, my lord, I
They-
say, my lord,
They,
if
they,
that,
they are in this practice. They see Eastern Congress, my lord, is experience hearing so many cases and.
All right, let us not get into all that.
Great.
And for the petitioner lordship,
I am appealing from the South Bengal State Transport Corporation, led by Mr. Arfan.
lordship petitioner was appointed as a Bodli driver in the year 1991, and after completion of probationary period, he was absorbed permanently as in the year 1993, lordship. And from 1993, he has been stagnated in the same post for more than 25 years, lordship. And no promotion has been given to even after repeated request, he has not been given any promotion, lordship.
Yes, you have taken instructions.
Yes, my lord. My instruction is he has appointed as a heavy vehicle driver, my lord. There is no scope for promotion. For such reason, we have
Career advancement scheme.
Yes, we have given, and he has received the same. And the two occasion, my lord, after completion of 10 years service, he has received the from 1st March 2003, and subsequently the second time he has received from 1st March 2013.
All right, you bring it on by way of a report on affidavit.
Yes, my lord. And another thing, my lord, lastly, in the COVID period, the SBSTC has given a promotion to every employee, and subsequently it was
You bring it or everything on the report.
Lordship, he was allowed to appear in the examination for promotion in the year 2016, and that
All right.
result has not been published, lordship.
Mrs. Dhabali. Learned counsel appearing on behalf of South Bengal State Transport Corporation, within bracket SBSTC, submits that the petitioner has been given the benefits of career advancement scheme, within bracket CAS, bracket closed, once after completion of 10 years of service, and second time, first time after completion of 10 years of service, and second time after completion of 20 years of service, full stop. Furthermore, additional benefits were given during the COVID period to the petitioner, full stop. Next, let the stand of SBSTC be brought on record by way of a report on affidavit to be filed by June 23, 2023, full stop. Exception, if any, by June 30, 2023, full stop. Next, matter to appear for further consideration under the same heading motion, bold, on July 3, 2023, full stop. What a bold have a server copy.
Grateful.
For the writ petition, and I am for the respondent.
Yes.
This is my exception. Will not kindly come to my lord's last order on 20th February 2023.
So what is their stand in the report?
Why not they have the RPF authority filed report. Why not specifically directed the respondent RPF authority to establish their claim that the order of the appellate authority, though allegedly passed in 2010, whether it was at all served upon the petitioner or not. They have admitted that they could not trace out the evidence. That is, they have annexed the postal report of the postal authority and other reports which would be evident that that was not served upon. Petitioner was suspended. Thereafter, in terms of the interim order, petitioner was to allowed to join in his service. Subsequently, my lord, the disciplinary proceedings was drawn up, and my lord came to a conclusion within that was beyond knowledge of the petitioner. My lord, thereafter, my lord, petitioner approached before this honorable court whether any final order passed by the disciplinary authority or not. Though my lord, petitioner earlier approached to the my lord, appellate authority regarding my lord, the one notice issued by the RPF authority that since my lord, before that petitioner has been acquitted in the criminal charges, and on that basis petitioner applied to the RPF authority kindly relinquish
appellate authority.
Appellate authority, and that was under consideration, and this honorable court was pleased to direct the appellate authority, if such appeal is filed by the petitioner, that that may be taken into consideration. But my lord, this after filing the they did not do anything since 2010. After filing the writ petition 2022, they have submitted, yes, we have already taken past order in 2010, and my lord, they could not produce any scrap of paper that whether that order was served upon the petitioner or not. And in the report, they could not establish a single scrap of paper that order was served upon the petitioner. Otherwise, petitioner even could not approach before the divisional authority. And in the meantime, petitioner retired in 2009, and petitioner is getting the pension, excluding almost more than 9 years service benefit. That is why my lord was pleased to direct the respondent authority to file a report to the effect that whether the order of the appellate authority at all served upon the petitioner or not. They could not establish their case in their report, and I have taken exception. In the RPF rules, there is a provision for service of notice. In a disciplinary proceedings, if the delinquent, may I? I want to. First thing, the service of notice, if the person, employee, delinquent employee,
RPF rules, which one are you referring to?
with regard to documents relied upon, it starts rule 153, 13. That is procedure state, entire procedure has been laid down. 153, 13, 15, nothing has been complied. Yes, one procedure of service 153.6. If देखे ना
Where he has absconded? Where has he absconded?
Certainly not, because he is getting pension, regular pension. How? He was in the barrack, and after retirement he went to his native village at Bihar.
So why are you pointing to 153.6?
Because the procedure they stated in their report that the person could not be traced out. My lord, it is, my lord, settled principle, my lord, if the document.
Please show me from the report what they're saying.
Yes. And kindly come to, my lord, page 11 is the postal receipt of 2016, 18/10/2016. And when they asked for, my lord, service report is 2023, next page, page 12. That they are asking after 7 years from the date of LS service, the delivery with reference, under reference in connection with your such and such as some Sundar Das. And report of the postal authority is 17. They have posted from Asansol headquarter and Asansol head office, page 17. They have given reply. With reference to above mentioned subject and reference, the record of the said article neither available in system nor in manual record, because the preservation period of the records of the articles is 18 months. Rule such and such. By their such act, I could not challenge the order of the appellate authority. Only they dealt with paragraph number 4, 5. Only they with regard to tracking of the record, postal record. And thereafter in paragraph number 8, they have described the order of the appellate authority. But nowhere they have stated that petitioner was absconded. Kindly come to page 5, last paragraph. Page 5, last paragraph.
Yes.
It is
I'm just going through the order of the appellate authority. Just give me a minute.
Appellate authority, nothing has been, no opportunity of hearing, no provision has been complied with. No personal hearing was given. You can leave it. Hmm. 217 rules. Rules 207. Personal hearing. 207.
You do one thing.
My lord.
You file a fresh appeal. Let them consider. Because as you know, there are several judgments that it is the criminal proceedings are or have to be proved beyond reasonable doubt. And this is on a balance of probabilities, preponderance. So I'm giving you the time to file the appeal.
Fresh appeal before
Fresh appeal before the appellate authority.
and setting aside the order of the appeal.
I'll
Great.
set aside the order and they will consider your case
My lord.
within a time frame.
My lord.
The petitioner was working as a constable with the Railway Protection Force, within bracket RPF. He has retired from service in 2009. From the pension payment order within bracket PPU, bracket close, issued on August 31, 2009, it appears that a period of 9 years, 6 months and 13 days have been excluded from the petitioner's length of service, full stop. Mr. Chattopadhyay, learned counsel appearing on behalf of the petitioner, submits that the petitioner's length of service should have been 38 years, 2 months and 4 days. Stop. Next. Criminal proceedings which were initiated under sections 304/114 of the Indian Penal Code have not been proved against the petitioner. Full stop. The additional sessions judge, Durgapur, by an order dated April 29, 2010, acquitted the petitioners. Full stop. Acquitted the petitioner. Full stop. The petitioner brought the said order of acquittal to the notice of the disciplinary authority. Full stop. By an order dated May 15, 2013, the Assistant Security Commissioner within bracket RPF stroke, the disciplinary authority held that an order of acquittal in the criminal proceedings does not quash the order passed in disciplinary proceedings. Full stop. The statutory appeal being disposed of, the length of service of the petitioner could not be shortened by more than 9 years. Full stop. Next. Mr. Mondol, learned counsel appears in favor of the Union of India. Full stop. It is the stand of the Union of India. Now, it is the stand of the RPF that the appeal dated July 8, 2013 was disposed of by an order dated October 17, 2016, after more than 3 years from the date of filing of the appeal. Full stop. Next. from an inquiry made on behalf of the respondents on an inquiry made on behalf of the respondents to the Department of Posts, India, the senior postmaster, Asansol, replied that no record of the article in question was available in the system or in the manual records because the preservation is made only for a period of 18 months. Full stop. Next. Since no records can be shown as to the delivery of the order dated October 2016 to the petitioner, October 17, 2016 to the petitioner, this court is of the view that the petitioner may not have been served by the order of the appellate authority. Full stop. Therefore, the petitioner's right to prefer a review from the same may also have been prejudiced. Full stop. The next, the respondent authorities were under an obligation to serve the said order under the Railway Protection Force rules, Railway Protection Force within bracket RPF rules, 1987, full stop. Next. Since the respondent authorities have failed to perform their part of the obligation, the order dated October 17, 2016 is hereby set aside and quashed. Full stop. Next, in the event the petitioner chooses to file an appeal within 2 weeks from date, the respondent authorities concerned, will consider the said appeal within 3 months of filing of the said appeal without raising the issue of limitation. Full stop. Next. With the directions aforesaid, WPA 2293 of 2023 bolded is disposed of. Bolded. Server copy, certified copy.
Only, my lord,
The exception
only respectful submission.
over in court today is written with the reports.
Petitioner is at present 83 years old. My lord, the appellate authority may allow one learned advocate or his friend for participation in the manner.
Appeal, the server copy, the appeal will be disposed of by a reasoned order upon the petitioner being personally represented and or through his
Grateful.
representative.
Grateful.
Full stop. Next. The reasoned order shall be communicated within 2 weeks of passing thereof.
Instead of 2 weeks, can you give 3 weeks because High Court server is down, my lord. We
Yes.
Not working, my lord.
No, Post of India. এক second, madam. Department of Posts. posts, comma, India.
I will prefer a instead of 2 weeks, 3 weeks, because my lord,
Instead of for preferring the appeal,
yes,
3 weeks kore din.
grateful, my lord, extremely grateful.
I beg to appear on behalf of the writ petitioner, my lord. My lord, the respondents. Writ, my lord, the petitioner became successful in the selection test of junior engineer, electrical grade 2. And like other, my lord, candidates, he was also found medically unfit. Other candidates were given opportunity of curing such defect with advice, medical advice, but the petitioner was not given such opportunity. She sought for 4 weeks time. Others were given 6 weeks time because the petitioner was suffering from, my lord, high myopia, and it is curable defect, and by LASIK surgery it was curable. He was not given such opportunity, others were given. This is the discrimination committed by the respondent authorities, my lord. And that's why, my lord.
Mr. Kole submitted that he was given an opportunity.
Yes, my lord, it appears, I am appearing now. Normally it appears that petitioner was giving more than time. My lord, I am giving you lots of 1 or 2 days. My lord, petitioner prayed for reconciliation on 28 September 2022. Lordship, kindly note the date.
Yes, I have already noted.
Because that I didn't appear. Because
in the order it is already noted.
Oh, then my lord, this he was advised to report, my lord, at the chamber of the director, Regional Institute of Ophthalmology, Medical College and Hospital on 17th November. From 20th.
How have you intimated him?
My lord,
How have you intimated?
Lordship.
My lord, it is clear from the annexure P6 at page
I am
42.
letting him submit. I have understood your case.
You will oblige.
Yes. Show me how you have intimated.
Lordship. He could have mentioned my lord, I also, that letter is not with me, but page 48.
That is why Mr. Kole had taken time. He is supposed to bring the instructions today.
No, Joseph, যেটা বলছে ওটা শুনুন। হ্যাঁ, যে ওকে করেছে। It appears from the papers, no doubt he did appear.
Where is it?
সেই চিঠিটা দিলেই তো পারতিস। আনবি তো, Joseph
You
যখন বল।
submitted orally on the last occasion. Today, I am reconsidering it again. So you have to bring the letter on the basis of which you made a submission.
চিঠিটা আনছিস না কেন? দেখ, Joseph যখন বলছেন তখন দেখ। আবার জোসেফ যা বলবেন তাই শুনবি, উল্টো পাল্টা বলিস না। ওকে ইনফর্ম করেছিস কিনা জোসেফ সেটা জানতে চাইছেন, সেইটা দে, চাইছেন উনি, সেটা বল না যে লেটারটা নেই, সত্যি কথা বল।
কাগজ আছে
that letter is not with Mr. Kole. I will request Mr. Kole to bring that.
Why has he not brought it? I do not understand. He has made his submissions on behalf, on that basis, I have recorded this order on February 13, 2023. Today we are in May.
That is my mistake, my lord. I apologize, my lord. That is my
3 months have gone. Why is the letter not here?
Lord, all records are here, but my lord.
That is the only document you are supposed to bring.
Yes.
Because you were supposed to get the instructions whether he has been discriminated against the other candidates or not. That is only the limited point of consideration.
Yes. Now, my lord, this discrimination point, probably I have taken the instruction. This may I?
Yes.
My lord, it appears that all other three candidates in same elements, my lord, they were given same opportunity to appear in the.
No, but that you have to show.
Yes, I have understood, my lord. I have
You have
understood.
to show that same opportunity was given. Everything what you're submitting today has been submitted on 13th of February.
Last
After
occasion.
3 months, we are again, this has come for reconsideration.
Page 45. Page 45. My lord, kindly come page 45. On 17th/11 was referred. Your lordship kindly see.
Second paragraph probably.
I have noted that.
Yes.
I have noted that, and that is noted in the order also.
That is our communication. Thank you.
And below probably the last line of that letter. And this is the 11th November.
You file a report on affidavit showing whether or not he has attended the medical examination. Let it be there on record.
That's
Ashun.
That's all right. কিন্তু এটা তো ঠিকই আছে।
আমার কথা বলিস তুই চুপ কর না।
It is submitted on behalf of
বুঝছিস না তো তোর এগেইনস্টে এখন কিছু বলিস না।
the West Bengal State Electricity Transmission Company Limited, within bracket WBACTCL bracket closed.
এটা দেখি তো আট লেটারে
Stroke respondents by Mr. Panja, former learned counsel.
একটা বুঝবি এটা হচ্ছে মেয়েরা জজ।
কি আনাবো আমি আর তো কিছু নেই।
রিপোর্ট
On
ফাইল
its
করতে
behalf,
বলছে।
that the petitioner has not been discriminated against the other candidates who had prayed for reconsideration of their candidature upon correction of high myopia by way of laser refractive surgery. Full stop. The opportunity that was given to the other petitioners were also given, other candidates were also given to the petitioner. Read a letter dated November 11, 2022, issued by the general manager within bracket HR&A bracket closed full stop. Since the petitioner did not appear for the medical examination, his candidature stood cancelled. Full stop. Next.
My lord,
It is submitted on behalf of the petitioner that
but kindly see annexure P11 48. He participated. He
Submitted
participated
on
in the
behalf of
further
the
examination.
that
But before curing the defect, such opportunity was not given to the petitioner.
no opportunity was given to the petitioner after curing the defect to appear for re-examination of his medical or re-examination of his eyes. Full stop. Next. Let the report on affidavit be filed by June 23, 2023, full stop. Reply if any, exception, if any, by June 30, 2023, full stop. Let the matter appear for further consideration under the same heading motion bolded on July 3, 2023.
এটা কবে? Well, that is why, Milord, I thought, Milord, this was there. That's why, Milord, I will not further.
You know, on the basis I have already recorded that in the order.
Faithful.
Because you have to say whether or not he appeared.
Yes, that was also
Before the-
there. He was also appeared. I will come out with a report.
You have to show that he has appeared. He has not appeared, sorry.
So, repeat, my lord, answer the statement on the last occasion, your lordship was pleased to direct me to file a written instruction.
1 second.
দিয়ে দেবে যারা পিটিশনাররা পায়নি তাদের দিয়ে দেবে।
আচ্ছা 21/22/23 দিয়ে দেব।
Yes.
Yes, my lord,
My lord, I am for the petitioner, man.
the portal was locked. There,
Now you have uploaded.
no, my lord, there, what the financial benefit which has not been given to them due to the anomalies in the annual performance report, what the department has considered their and decided to give them in the next financial.
That I have understood. Still, by which time? That is the important.
23 this year.
When will you give? You have to give me the time limit by which you will be giving them.
The annual performance report টা কখনো জানা আছে?
10th, my lord, the annual performance report in respect of year 2022-23 has been directed to be filed, my lord, within 10th May 2023, my lord. That has already been passed, my lord. Already over.
Please, they are saying that you will be given the benefits, whether or not your name is uploaded, whether or not your APAR is considered or not, you will be given the benefits. I am asking them till by when will they give the benefits?
That is to be
This
clarified.
year 22-23, when the annual performance report will be prepared.
That has, the time is over.
Or others.
That the time.
That time is over.
Time is not over.
10th May. এটা দেখুন। 10th May last date. It may be extended.
You have a copy?
Yes, I have a copy.
Please read. You have to tell me.
But,
Because if I just dispose it off on the basis of this written instruction, I do not know when you will give the benefits.
specific time is not mentioned here. My lord.
I have understood that. That is why I am asking you.
My lord, let me come back 1 second to.
Again, once again.
But since this is the only the instruction.
When have you given the benefits to the others?
My lord, let them, in the meantime, my lord, let them do.
22, before October 22, and the entire process will be completed. It will be completed by October. My lord. It will take some time.
By October 2023.
2023, 20,000 candidates. All.
Yes, but it is because of your mistake, they did not get it. Yes, what are you saying?
Since
My
the
lord.
CMOH has admitted that, that's why the National Health Mission has considered that they will be given the benefit. This year, since it could not be given in that year.
It's a one-time benefit.
No, my lord, since, my lord, we have been given average, my lord, in the APR, my lord, we will not be given the incremental benefits, my lord. That will affect, my lord, all the further years, my lord. That is our contention, my lord.
Although they have come belated, not that they were in time. But still,
My lord, it is.
still the CMOH has.
No, the APR has to be corrected. because
There was a time limit.
My lord, the
that
authority,
has to be corrected.
But
Now,
there
you-
was a time limit.
my lord, if your lordships consider the authorities on several on several occasions, my lord, they have communicated to the National Health Mission. My lord, they have not taken any steps. Rather, they have told that, my lord, we will not be doing anything. That's why, my lord, we have to come before this writ court, my
The
lord.
National Health Mission was communicated, but much prior to the October to 2022.
Then
the
that
APIs
must
need
have
to
been
be
done by this
corrected.
time.
Since the CMOH and CMOH has admitted that yes.
By
there are
when will
anomalies.
you complete the rectification? It is not only about the benefits, Mr. Dotto. It is also about the correction of the APARs.
My instruction only that since they could not be given the benefit due to the anomaly.
Your instruction I have understood.
So therefore, only the financial benefit they will be given this year.
That I have understood. But the APARs need to be corrected.
Specific date has not been given this instruction. ma'am.
Also, the APARs need to be corrected. Please try to understand. You cannot leave their APARs as average.
APR is prepared every year. Not that
It is prepared every year, but the evaluation that they are challenging,
last year.
yes,
My lord.
of 2021, 2022, that has to be corrected. You cannot leave it as average.
My lord.
It will ultimately affect them.
Yes, but my lord, we could not do that even after they have come belated since the portal was locked, the central portal.
My lord, as per my instruction, my lord, the portal is now open, my lord.
They will be given, my lord.
They will be given the.
Then, my lord, they kindly keep the matter pending, my lord.
Ashwin,
I'll ask.
Ashwin,
my
In the
client.
meantime, let them do this, my lord.
it is submitted on behalf of the petitioners that now the portal
সময় লাগে অনেক।
for correction, for uploading of the annual performance report within bracket APR of the petitioners has been opened by the central government, mission director, National Health Mission, full stop. Therefore, there is no impediment in rectification of the APR for the period 2021-2022, which was admittedly wrongly uploaded by the respondents concerned. Full stop. Let such rectification be made within 6 weeks from date. Full stop. A written instructions on behalf of the state advocate, on behalf of the state respondents is submitted in court today. Full stop. Such written instructions are retained with the record. Full stop. From the written instructions, it appears that the program officer -1, NHM and Secretary is willing to give the benefits, incremental benefits for the year 2021-2022 to the petitioners, along with the payment of the benefits for the year 2022-2023. Full stop. It is submitted by Mr. Dotto, appearing on behalf of the state, the next website, that such benefits will be given by October 2023. Full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on July 3, 2023. Bolded. Server copy. Let us see whether they upload the correct APR or not. Great production.
After the your topic was this to directly take copy has been noticed upon the district judge at last.
You are for the state.
I am for the High Court administration, ma'am.
Who is for the state?
In compliance with the lordship's order, I have served and he has received the said and improved order, my lord, page 24. Kindly page 24. Order 16th April 2021.
You serve upon the GP's office once.
Yes, I have, on the last occasion, I have filed the evidence service.
Please serve upon the GP's office. Government figures. You have?
Yes, my lord. On the
দেখুন তো এটা কোথায় জিপি's অফিসে কোথায় সার্ভ করেছিলেন? এটা তো রেজিস্ট্রার জেনারেলকে সার্ভ করেছে।
order dated 20 February 20.
জিপির অফিসের কোথাও তো আলাদা একটা থাকে।
2 copies have been served upon the GP's office.
Where? How?
I have annexed.
জিপির অফিসের তো এটা নেই একবার দেখাও ওনাকে দেখাও। আদার ম্যাটার্স রিলিজ করে দাও ওনাকে দেখাও।